The House will come to order. Calendar for the day. The first bill on the calendar for the day is House File 1019. The clerk will report the bill.
House File number 1019, number 1 on the calendar for the day, an act relating to civil actions, the first engrossment.
I recognize the author of the bill, the member from Ramsey, Representative Feist, to explain House File 1019.
Thank you, Mr. Speaker. House File 1019 is important legislation that allows Minnesotans to seek justice. Minnesota is the only state in the union that has a statute that mandates that an injury claim dies when the person dies and it does not survive for the benefit of their surviving family members. This statute has produced glaring injustices to many families in Minnesota and allowed some to escape accountability for wrongful acts. On occasion, an elderly person or someone who has fallen ill that has a valid injury claim will encounter resistance in the resolution of claims or delay of the legal process. Because of current law, there is a perverse incentive to stall a claim in these situations, which can produce an unfair windfall to the party that caused the harm. This legislation allows for a family to recover all the damages a person suffered before death in a wrongful death or injury action, as is the case in all other states. This bill will eliminate any benefit for delaying resolution of a claim. Minnesota is not a litigious state, and we receive high marks for fairness in our civil legal systems. This bill will ensure that injury claims are allowed to move forward to the conclusion for the benefit of family members and to ensure accountability for the harm their loved ones have suffered. And I want to take a moment to thank the people who came and testified in committee, shared their stories of their family members' pain and suffering, and how important this legislation is. And I would urge members to support this bill. Thank you.
There's an amendment at the desk. The clerk will report the amendment.
Niska moves to amend House File number 1019, the first engrossment. The amendment is coded A3.
I recognize the author of the amendment, the member from Anoka, Representative Niska, to explain the A3 amendment.
Thank you, Mr. Speaker and members. Thank you, Representative Feist, for this bill. I am a co-author on this bill. It is a good bill. It's a bill. It's not a perfect bill, but it is a good bill. And those of you who are on committees with me and all of you here on the floor, you know that I speak a lot on the issues related to civil litigation. Civil litigation is an issue that I'm very passionate about. I've spent most of my professional career in civil litigation in one way or another. I've represented plaintiffs and defendants in a lot of cases in courts actually around the country and as well as in the state of Minnesota. I've clerked for 2 judges on the 8th Circuit, and I've done a lot of work advising businesses on how to avoid litigation. And civil litigation is very, very important on both ends of the equation. It plays an important role in providing compensation for victims, as well as accountability for wrongdoers. And it has a long, proud history in our country and in our state. The right to jury trial for civil lawsuits is referenced in the 7th Amendment in the U.S. Bill of Rights. And the Minnesota Constitution protects the right to remedy from wrongs in Article 1, Section 8 of our Bill of Rights. This is really important. It's something that we should all be for. But civil litigation can be a blunt instrument. It can create situations where we create negative incentives for frivolous and costly litigation, or in the case that we're dealing with today, bad incentives to try to delay meritorious litigation. As President Lincoln, who watches over us, advised his fellow attorneys, discourage litigation, persuade your neighbors to compromise wherever you can, point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. So it's our job, I believe, as a legislature to very carefully calibrate that system. We need to balance the rights of potential plaintiffs as well as potential defendants. And I often speak on the floor and in committee about situations where we're going too far in the other direction, sometimes encouraging frivolous litigation, encouraging bad incentives for plaintiffs' lawyers or for those who might want to game the system. But this bill, the way it's written and the direction it's going, is a necessary corrective where we've gone too far in the other direction. It is better than the status quo. Minnesota should not be an outlier and creating bad incentives for defendants to drag out litigation in the hopes that a plaintiff dies. But the bill isn't quite there. It doesn't quite hit the right balance. I believe we should rein in the limitations periods a little bit. We should be mindful of especially nursing homes that are in very difficult financial situation, and this might potentially create some additional problems. And so in order to try to get it a little bit more towards the right balance, Mr. Speaker and Representative Feist, I'm offering the A3 amendment today. Thank you.
Further discussion to the A3 amendment. I recognize the member from Ramsey, Representative Feist.
Thank you, Mr. Speaker, and thank you, Representative Niska, for this very lawyerly amendment and this opportunity to have a very lawyerly nerd debate on the House floor. So I agree that striking the right balance is incredibly important, and this bill is the reflection of conversations with stakeholders and compromise in terms of creating some limitations on that liability as it extends past the death of the victim. But I do not support damages cap for a variety of reasons. One of them, the ones that you so eloquently cited to, I believe that our constitutional right to a trial by jury and to seek a remedy is incredibly important, and I feel like this bill does strike the right balance in making sure that we have those rights. In addition, in states that do have damages costs, they don't really save a lot of money, except for insurance companies that get really an unfair windfall when there are these artificial caps. In addition, I don't think that the legislature is the best decider of what those caps should be, and that's another reason why I don't really support damages caps. I also believe that they really limit those most severely injured who have damages that might exceed the artificial cap, in this case, $500,000. And to conclude, Minnesota, even though we don't have damages caps at all, we actually have the lowest malpractice rates in the country, which is interesting. So I would respectfully not support this amendment, but thank you for bringing it.
Further discussion to the A3 amendment. I recognize the member from St. Louis, Representative Zalesnikar.
Thank you, Mr. Speaker. And members, I appreciate the amendment offered today by Representative Niska, and I appreciate the bill today, Representative Feist. I understand what the intent is, but I'm very concerned with the unintended consequences, and I say that from the fact that we have a very aging population. And we have a situation right now in this biennium where we're not funding nursing homes. And we are in a situation where I'm concerned that the litigation from care plans is, and this is the reality, every time a resident falls, the nurse has to do a new assessment in a nursing home with a new intervention. And if they do not have adequate staff to do that intervention, there could be a fall, there could be a bleed, there could be checks weren't done every 2 hours, they weren't done every hour, and these mandates are set by the government many times. And as we go down this slippery slope, my concern is the costs for nursing homes and the court cases could become an incredible factor, because litigation is not, even if it's not a case that is substantiated, is very expensive, and those costs are going to be incurred, and it's going to further erode the very piece we're trying to accomplish, is protecting vulnerable adults. And so I rise today with concern over, I understand the intentions, and I have the same ones of wanting to protect people. I just think this bill needs to have more scope. It needs to have more provisions in it as far as the length of it, and fine-tuned further. And to the point of Representative Niska, I think that amendment makes sense. And I urge us to use caution, because I think that there are some situations in caring for seniors where we cannot prevent all things from happening. And so when a care plan is not followed, that can be seen as neglect. And it is not an intentional neglect or any willful act of harm. And so you can have great nurses and great aides in settings like this that are limited. And we as a legislative body are limiting them by not funding nursing homes. And so for that reason, I would like this bill to be further refined to account for some of these variables and make the scope and the provisions changed. Thank you, Mr. Speaker.
Further discussion to the A3 amendment. I recognize the author of the amendment, the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Zalesnikar, for those comments. And Representative Feist, thank you for the exchange and for the conversations we have had, both in the Judiciary Committee and as this bill was coming to the House floor. I do share Representative Zalesnikar's concerns, especially in light of the broader budget situation that we're in and some of the particular stakeholders that might be negatively impacted by this. I do, however, understand that there are continuing discussions going on about doing that kind of refining between now and potentially when a companion bill passes through the Senate and potentially comes back to us. And so for that reason, today I'm withdrawing the A3 amendment. Thank you.
Representative Niska has withdrawn the A3 amendment. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 1019.
Third reading. Discussion to House File 1019. I recognize the author of the bill, the member from Ramsey, Representative Feist.
Thank you, Mr. Speaker, and thank you for the good discussion today. This is an incredibly important bill, and as Representative Niska said, there are some conversations ongoing. We do want to make sure that we strike the right balance, but I do believe the right balance is holding nursing homes accountable if they are, in fact, negligent, and this will ensure that they do that. We had someone come to committee and share the story of a parent who was sexually assaulted in a nursing home. And when that parent died of old age, then that nursing home was not held accountable. And that is the type of injustice that this bill seeks to address. So I agree that balance is important, but right now this bill is in the interest of justice. And as I mentioned, Minnesota has the lowest malpractice rates in the country. So nursing homes are able to afford that insurance, and it will cover them if, in fact, they had a duty that they breached and it caused harm. So I would encourage folks to vote yes on this bipartisan bill. Thank you.
Any further discussion? Seeing none, the clerk will take the roll on House File 1019. Members, please vote. Would the clerk please call the name? Will the clerk just wait while we find the member who's voting remotely? The clerk will close the roll.
There you go.
There being 77 ayes and 48 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 463. The clerk will report the bill.
House File Number 463, number 2 on the calendar for the day, an act relating to capital investment, appropriating money for the Rural Finance Authority.
I recognize the author of the bill, the member from Hennepin, Representative Vang, to explain House File 463.
Thank you, Mr. Speaker. I'm pleased to be carrying this bill for farmers all across the state. This bill was born out of the farm crisis in 1986 to deliver farmers affordable loans and services. Some of these programs are the beginning farmer loan, loan restructuring, seller sponsor, agriculture improvement loans, and livestock expansion loan programs. And they remain an important tool for farmers to utilize. This bill has broad bipartisan support, and I look forward to your continued support.
There is an amendment at the desk. The clerk will report the amendment.
Anderson PH moves to amend House File Number 463. The amendment is coded A1.
I recognize the author of the amendment, the member from Pope, Representative Anderson, to explain the A1 amendment.
Thanks, Mr. Speaker and members. And Chair Vang, thank you for bringing this bill forward. As you mentioned, it's an excellent bill for agriculture, and I'm a supporter. I signed on to the bill with you. It's bipartisan. In fact, Representative Burkle carried a bill that, if it's not identical, is very similar to the one that you carried as well. So the funding is needed, and we all support that. What my amendment does simply is it doubles the amount of authorization that the RFA is eligible to do. And it doesn't mean they're going to go out tomorrow and bond for $100 million. It just gives them the authorization to do so. In looking back at some of the past history, as Chair Vang mentioned, this program began back in 1986, and they had the authorization for $50 million. In more recent years, in 2017, the authorization was for $35 million. In 2018, also for $35 million. And in 2020, a couple of years ago, the authorization was for $50 million. So the need is there. And as Chair Vang mentioned, this authorization of the current authorization could run out by October. So we need to act on this legislation. And again, the amendment simply doubles the authorization amount that they can do and saves them from coming back here again as quickly as they may have to if the use is higher for these type of loans through the Rural Finance Authority. So, Mr. Chair, I would ask for a roll call vote on the amendment and encourage a green vote.
Representative Anderson has requested a roll call vote. Seeing 15 hands, there will be a roll call on the A1 amendment. Is there any discussion to the A1 amendment? I recognize the member from Hennepin, Representative Vang.
Thank you, Mr. Speaker, and thank you, Representative Anderson, for the amendment. If we could give more, I will be happy to accept more. However, throughout session, we've only discussed the $50 million amount, and your colleagues have a bill that supports exactly $50 million. And this is the amount that stakeholders all across have asked for. So there's global agreement for the $50 million, and by taking your amendment, by doubling it, it will also affect dollar amounts in other areas, like Chair Lee's bonding bill that I know he's worked very hard on. And so I will ask members to vote no on the amendment.
Any further discussion to the A1 amendment? I recognize the author of the amendment, the member from Pope, Representative Anderson.
Thanks again, Mr. Speaker and members. Well, again, this is not going to cost the state any additional funding. This is a user-financed program. In fact, the state makes a little bit on this on the RFA program. The interest rates they charge cover their cost of the bond issuance, and it's a good program. So again, I would encourage a green vote. This doesn't mean they're going to go out and bond for this amount today or tomorrow, but it gives them the authority to do so. And again, it's a good bill for a good program, and I would encourage a green vote on the amendment.
Further discussion to the A1 amendment? I recognize the member from Carver, Representative Nash.
Thank you, Mr. Speaker. And would Representative Anderson, PH, yield to a question?
He will yield to a question, Representative Nash.
Thank you, Mr. Speaker. And Representative Anderson, we were just told that this would adversely affect Chair Lee's targets in his bonding bills. Can you attest to or corroborate that so that the entire chamber can know and be informed as to how they're going to vote?
I recognize the member from Pope, Representative Anderson.
Mr. Speaker, thanks, Representative Nash. I have not heard that before. I think I would prefer to phone a friend, Representative Erdahl or Representative Lee. I can't say one way or the other for sure if that would impact the state's bonding authority.
Representative Nash.
Thank you, Mr. Speaker. Would Representative Lee yield to a question?
Representative Lee will yield to a question. Representative Nash.
Thank you, Mr. Speaker. And Chairman Lee, can you tell me how increasing this number from 50 to 100 would adversely impact your ability to write your own bonding bills?
I recognize the member from Hennepin, Representative Lee.
Thank you, Mr. Speaker, and thank you, Representative Nash, for the question. So, debt guideline number 3 from MMB, this counts towards the amount of debt that we could take per biennium for the state. And so I think what Representative Vang, Chair Vang is referring to is if we were to authorize this, this will count towards the amount of debt that we could take on for MMB debt guideline number 3, and that's included in the MMB forecast.
Representative Nash.
Thank you, Mr. Speaker. Well, that's not how I understand it. I understand that these are bond proceeds and that these are paid for by the farmers and paid back. So it does not actually come out of the general fund at all. So there's no general fund hook into this, so therefore it couldn't count against your targets at all. So let's be clear that this does not adversely impact your ability to bond or anywhere else. This doesn't come out of the general fund. There's no connection, and I would urge a green vote. Thank you.
Seeing no further discussion, the clerk will take the roll on the A1 amendment. Would the clerk please call the name of the member who is voting remotely?
Hassan.
Hassan votes no.
Hassan votes no.
The clerk will close the roll. There being 59 ayes and 70 nays, the motion does not prevail and the amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House Bill number 463.
Third reading. Discussion to House File 463. I recognize the member from Meeker, Representative Erdahl.
Thank you, Mr. Speaker and members. And this, of course, is a very important program for our farmers. It's frequently been in the capital investment bill over the years. And frankly, I wish we'd passed this amendment. It's well within the debt ceiling limit that we have. But I do have a question. Back in 2018, when I was chair of the committee, we were short a vehicle for the capital investment bill, and lo and behold, Representative Tim Miller had a bill for RFA, and so we latched onto that, and that's how Tim Miller became the chief author of the capital investment bill of 2018. And so, with that little scenario, would Representative Vang yield for a question, please?
Representative Vang will yield to a question. Representative Erdahl.
Thank you, Representative Vang. Could you tell me, do you have any indication or do you see any possibility where your bill today could become a vehicle for a future capital investment bill?
I recognize the member from Hennepin, Representative Vang.
Thank you, Mr. Speaker, and thank you, Representative Erdahl. No, I have not received any indication that it will be a vehicle bill, but I don't mind carrying the bonding bill either.
Representative Erdahl.
Thank you, Mr. Speaker.
Further discussion to House File 463. I recognize the author of the bill, the member from Hennepin, Representative Vang.
Thank you, Mr. Speaker. I'm not going to belabor this any further. There's a strong support for this bill. It's a good bill, and I ask for your continued support. Thank you.
The clerk will take the roll on House File 463. Would the clerk please call the name of the member who's voting remotely?
Hassan.
There you go. Are you there? She hung up. Sorry, she hung up. Okay, here you go.
Hassan votes aye.
Hassan votes aye.
The clerk will close the roll. There being 129 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2204. The clerk will report the bill.
House File number 2204, number 4 on the calendar for the day, an act relating to metropolitan government, the first engrossment.
I recognize the author of the bill, the member from Hennepin, Representative Freiberg, to explain House File 2204.
Thank you, Speaker. The legislature is required by statute to develop new districts for the Met Council in every year, ending in a 3 after both the decennial census and congressional and legislative redistricting have been completed. The purpose of redistricting is to equalize Metropolitan Council district populations following the past decade of population expansion. And between 2010 and 2020, the metro region's population expanded by 11%. So redistricting addresses that growth in drawing new districts. Based on this, each Metropolitan Council district should contain approximately 1/16 of the metro area's population, and that works out to exactly 197,251 people. Now, the maps that you have before you, I just emailed you out a copy to the GIS website if you would like to look at both the metro area as a whole or the individual Met Council districts. The maps that you will see there were developed with a couple principles in mind. One goal was keeping communities of interest together. So generally speaking, suburbs, exurbs, and core cities are not in districts with each other, except where it's necessary to maintain approximate population equality among districts. And on that note, population equality is also a goal. The average deviation in district size is 0.85%, and the district with the largest deviation is 1.65%. Another goal was not splitting up cities unless it's unavoidable for population equality reasons. Under this map, split cities include Edina, Maplewood, Minneapolis, St. Paul, and Woodbury. A final goal is relative stability with existing districts. The map has been posted online for a few weeks. We had a good hearing in the State and Local Government Committee. As I said, I emailed the URL to the link where you can find them all to all members. So I hope you will look favorably upon this, and thank you for your consideration, and I'm happy to stand for any questions.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 2204.
Third reading. Discussion to House File 2204. I recognize the member from Carver, Representative Nash.
Thank you, Mr. Speaker. I forgot I was supposed to say something nice about this bill. If you like benign maps that maybe split the cake through Edina in half, I gotcha, Representative. Then this is the bill for you. This is a completely non-controversial bill, and I love the fact that somebody talks about GIS on the floor other than me. So vote green.
I recognize the author of the bill, the member from Hennepin, Representative Freiberg.
Hooray for GIS. Vote green, Mr. Speaker.
The clerk will take the roll on House File 2204. Would the clerk please call the name of the member who is voting remotely?
Hassan.
Hassan votes aye.
Hassan votes aye.
The clerk will close the roll. The next bill, there being 114 ayes and 13 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 3. The clerk will report the bill.
House File number three on the calendar for the day, an act relating to elections, the fifth engrossment.
I recognize the author of the bill, the member from Hennepin, Representative Greenman, to explain House File 3.
Mr. Speaker and members, I'm grateful to be here today to present House File 3, Democracy for the People Act. And I'm hoping, given our last three bills went so quickly, that this one will also go quickly. This is a comprehensive democracy legislation that invests, protects, and strengthens Minnesota's best traditions of voter participation, sound election administration, transparency in government, and grassroots people-powered democracy. This package of common sense solutions rests on the simple premise that our state works best when Minnesota voices are at the center of our democracy. All Minnesotans, Black, brown, Indigenous, white, Metro, Greater Minnesota, suburban, rich, poor, Democrats, Republican, independents, and folks with no party at all. Minnesota voters, not corporations, not foreign influences, not outside forces, are at the center of our democracy. This bill responds to the urgency of the moment and the overdue work in Minnesota to strengthen our voting, our campaign finance, and our disclosure laws to empower Minnesotans and strengthen our elections. In the last few years, we've seen our democracy tested in unimaginable ways. A global pandemic, a violent insurrection at our nation's capital, a rise and an influx of dark money, the rising climate of disinformation, rhetoric, and fear, and foreign meddling in our elections. And year after year, we've continued to see these problems grow. But the fact is, Minnesotans are invested in our democracy. In 2022, the first election since January 6th, with democracy firmly on the ballot, 2.5 million Minnesotans showed up from across the state, turned out not just to participate in our democracy, but to protect it. The promise of American democracy is that we together have the power to improve it, to expand it, and to strengthen it. And we are here today with a bill in front of us that acts. It acts to strengthen the voice of voters, of Minnesotans in our democracy. The three articles in this bill are a comprehensive effort to do that. Article 1 strengthens the freedom to vote. It does that by modernizing and expanding voter registration with automatic voter registration when folks get a driver's license or ID card. It allows 16 and 17-year-olds to pre-register so they can be on the rolls when they turn 18. And it gives Minnesotans who want one a choice to sign up to permanently be able to vote from home. The second article protects voters in our election systems. It ensures that voters have access to voting materials that they need in the language they need it. It includes a strong provision to protect voters and volunteers from intimidation, harassment, and deceptive practices that can interfere with their freedom to vote. And it gives law enforcement the tools they need to fight deceptive practices and acts of disinformation that are specifically intended to interfere with the vote. Article 3 contains transparency and disclosure provisions to ensure that Minnesotans know who's spending in our elections and that we can keep foreign influences out. It closes dark money loopholes and requires disclosure of secret spending so that voters know exactly who's spending money on ads and materials to influence their vote. And it extends the prohibition on foreign influences to foreign influence corporations. It extends the existing prohibition on foreign nationals contributing to our elections. This will limit the influence of foreign forces in Minnesota elections by closing a loophole in our law. As a voting rights lawyer who's worked on this policy across the state, I can tell you that this is a set of good reforms that have been passed in red states, in blue states, in purple states. It's good for voters across the spectrum. And because this isn't about us, This is about voters. It's a bill about what we're doing to ensure that all voters of every political persuasion, background, and zip code have a stronger voice in our democracy. It's about how it impacts voters and their participation. In the last 3 years, we've seen our democracy tested. But this bill puts Minnesotans at the center of our democracy and our government and moves us forward. This is a bill we should all be able to support. I look forward to the conversation, and I ask for your green vote. Thank you.
There's an amendment at the desk. The clerk will report the amendment.
Greenman moves to amend House File Number 3, the fifth engrossment. The amendment is coded A30.
I recognize the author of the amendment, the member from Hennepin, Representative Greenman, to explain the A30 amendment.
Thank you, Mr. Speaker. This amendment does a few things that updates the bill in line with the original intent and technical feedback that we've received. It adds language making explicit that county attorneys have the power to enforce the civil litigation provisions of the voting rights of the voting intimidation and deceptive practices provision. It eliminates 2 redundant effective dates to avoid confusion, and it revises the AVR language, the portion in Article 1 that protects individuals in case of government makes a mistake in the registration process. The section deals with voter registration, and we're taking out the language that goes beyond registration. This amendment conforms to the original intent of the provision. And I'd ask you for your green vote.
Is there any discussion to the A30 amendment? I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and Representative Greenman. I am concerned about the potential for election interference by elected officials and people in what we're adding in, 87 county attorneys into the late in an election process to make an allegation against potentially a candidate or some other political group under this provision. And in particular, my concerns were heightened in this last week. We have a lot of great county attorneys. The Anoka County Attorney, Brad Johnson, nonpartisan, great guy, but he is an elected official. We do have some more partisan county attorneys, and in just this last week, we saw an incident that really concerns me, especially as it relates to this, in which the Hennepin County Attorney did some
Point of order, Mr. Speaker.
Representative Long, state your point of order.
Masons 124, we are not allowed to engage in personalities on the House floor in debate.
I'm going to defer ruling on this point of order, but Representative Niska, I will give you back the floor. I ask that you refrain from engaging in personalities and that you confine your remarks to the question before us, which is the A30 amendment to House File 3. Representative Niska.
Thank you, Mr. Speaker, and I think it's very important that we, as we consider whether county attorneys should be given, all 87 of our county attorneys are given additional enforcement authority, that we consider very carefully, especially in light of recent events, whether that is a good idea. And in particular, we saw a county attorney just this last week in a press conference lambasting the governor and the attorney general of the same political party, and the lead argument for why it was a bad idea was
Representative Long, state your point of order.
Same point of order as before, Mr. Speaker. Masons 124, we cannot engage in personalities in debate, and I would ask that members refine their remarks to the amendment at hand.
Representative Long, could you please explain what it is about Representative Niska's remarks that you feel is violating our rules?
Sure, I would be happy to. When we were talking about individual personalities, individual characters, that is not the subject of the debate before us, which is an amendment to a bill, the A30 amendment brought by Representative Greenman.
Representative Niska, please refrain from discussing the personalities of individuals and confine your remarks to the A30 amendment to House File 3. I will give you one more opportunity, Representative Niska.
Thank you, Mr. Speaker. My comments are directly to lines 1.7 and 1.8, and to the officials that the amendment is empowering to do that, and to recent, within the last week, historical evidence about that should cause us to be very gravely concerned. And Mr. Speaker, I hope that on the House floor we are able to discuss whether what the implications are of the amendments, and in particular how they might play out in the real world in light of evidence that we see in the real world about whether those things are a good idea. And so my question to Representative Greenman, if she will yield, would be whether—
Representative Greenman will yield to a question. Representative Niska.
Thank you, Mr. Speaker. My question to Representative Greenman is, please help me satisfy or allay my concern that all 87 of the county attorneys across the state of Minnesota will not use the additional power that they have been given to interfere in Minnesota elections, for example, by suing candidates or suing political groups on the eve of an election, even for something that after the election might be dismissed, but interfere in the election in that way. Thank you.
I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair. And, you know, it's interesting. I wasn't expecting this to be the thing that I heard from your side about. I actually got some questions when I was talking to folks about why they weren't included to folks across the aisle. We think it's important that the Attorney General, which currently has civil enforcement authority, as well as county attorneys have discretionary authority, as well as individuals who are harmed. In this bill, county attorneys have criminal enforcement authority. We think it's just right. But if you read the bill, and you know, being a lawyer, you know that people have to have a reasonable basis. That's what's in the statute to go into court. You know that they have to, when they go into court, they actually have to fulfill the provisions of the bill. So I think it's a bit of a red herring, and I actually think that when we talk about provisions that are meant to and are tailored to protect voters from intimidation, coercion, violence, that our local prosecutors, our local law enforcement have the ability to enforce that.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Greenman, for clarifying as well some of the problems with the underlying bill. I do think this bill is extremely problematic. I understand that there is an election misinformation and intimidation and some fraud problems that are legitimate that the state can go after, but I think that the way that this is structured, it does create incentives for a partisan elected statewide official, as well as 87 other elected officials, some of whom are, all of whom are elected in nonpartisan elections, but some of whom can be quite partisan. And again, I think we saw an example of that this last week that we should not ignore. We saw an example of that we should not ignore as we consider this. And this amendment takes what I think is a problematic enforcement mechanism and makes it even worse. And so, members, I hope that you will vote against the A30 amendment.
Any further discussion to the A30 amendment? I recognize the member from Carver, Representative Nash.
Thank you, Mr. Speaker. I would urge a no vote on this, as Representative Niska said, because it does effectively create another group of people who, if they chose to be partisan, and many do, could effectively become an agent of change for the outcome of an election. And you know, I'm not going to push it to the point where I get ruled out of order for personalities, because Representative Niska was well within his rights, but I do think that this is problematic. I don't want to go down this road, Representative Greenman. I think that, you know, we saw one very prominent event recently, and I would be flabbergasted if you didn't know what I was talking about, so I won't use the actual office holder of that, but Representative Niska is exactly right. Why would we put into the hands of some county attorneys, as Representative Niska said, who can be and have been, as we've seen, partisan and capricious in how they do things? Why would we give them an opportunity to have an ability to tilt the outcome of our elections? So, and Mr. Speaker, I'm going to ask for a roll call on this.
Representative Nash has requested a roll call vote. Seeing 15 hands, there will be a roll call vote on the A30 amendment.
Thank you, Mr. Speaker.
Nash.
Please vote no.
Further discussion to the A30 amendment. I recognize the author of the amendment, the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker. And the other thing I would note as we talk about county attorneys is, unlike us, county attorneys are attorneys who are bound by a code of ethics and actually can get sanctioned. So when I think about who I'm worried about enforcing our laws, I'm going to trust Kim. So I'd ask members to vote yes on this amendment and vote yes.
Mr. Speaker.
Representative Nash.
I'm going to raise a point of order under Mason's 124. We do have ethics over here, Representative Greenman, and I'm hoping that you misspoke by that sideways comment, but we do have a code of ethics, and I think that's why we're standing up here saying that we don't want this to be in the hands of some who, as we have seen in the news, become partisan. So we do have ethics, and Mr. Speaker, I would ask you to at least comment on this, because by saying that at least my side doesn't have ethics, I'm personally offended. Thank you.
Representative Nash, would you please cite the rules and customs that you believe?
Mr. Speaker, I rose under a point of order under Mason's section 124 personalities. By saying that we do not have ethics, you are impugning our motives.
I'll remind members to avoid personalities and that it is not allowable to arraign the motives of a member. Is there any further discussion to the A30 amendment? Seeing none, the clerk will take the roll on the A30 amendment. Would the clerk please call the name of the member who's voting remotely?
Hassan.
Hassan votes aye.
Hassan votes aye.
The clerk will close the roll. There being 70 ayes and 59 nays, the motion prevails and the amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Torkelson moves to amend House Law Number 3, the 5th, and Grossman as amended. The amendment is coded A22.
I recognize the author of the amendment, the member from Brown, Representative Torkelson, to explain the A22 amendment.
Thank you, Mr. Speaker and members. The A22 amendment deals with a small but very important portion of this bill regarding express advocacy. For those who wonder kind of what that's all about, it's all about free speech, honestly. The Supreme Court has ruled that the Constitution protects an individual's right to free speech and to privately associate with an organization that shares its beliefs, and do that anonymously. That's the decision of the Supreme Court, of the highest law of the land. Express advocacy language in this bill changes things so that the lines that are drawn regarding independent expenditures and the political advertisements that they present now will not, instead of having the magic words that actually define clearly what's allowed and what's not allowed, we now have nebulous language that's going to make it very difficult for those that produce these speeches as a matter of free speech to express themselves. While I would like very much that this be removed from the bill, we're not offering that amendment, but we are offering an amendment that would actually soften things a bit by making sure that it's not impacting free speech year-round. We are going to, with this amendment, we would restrict it to the 60 days before an election and 30 days before a primary election. This will, at least to some portion of the year, protect the free speech of these individuals. Thank you, Mr. Speaker.
Further discussion to the A22 amendment. I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker, and thank you, Representative Torkelson, for letting me talk about this important bill. What this provision does is it applies to Minnesota the federal express advocacy standard that currently exists in federal law. That's actually been in federal law for 20 years. It's been litigated up and down, and I don't think you want to hear a campaign finance lawyer talk about the litigation. What I will say is it is the law of the land federally. It is in most states. And what it does is say that if you are an independent expenditure and you're required to disclose under Minnesota law because you say vote for or vote against, you have an ad that is so clearly a campaign contribution. What this says is if you don't say vote for or vote against, but it is susceptible to no other reasonable interpretation other than that, you also have to disclose. This is just closing a loophole about the money that's being spent outside of reporting, that's being spent across the state. And when you talk to Minnesotans, when I talk to Minnesotans, they talk about the flood of money. They talk about the flood of dark money. And this is also a good opportunity, since you brought up the Supreme Court, for me to quote probably my least favorite Supreme Court justice, but I will quote him. Justice Scalia said that requiring people to stand up in public for their public acts fosters civic courage, without which democracy is doomed. For my part, I do not look forward to a society which campaigns anonymously, hidden from public scrutiny, and protected from accountability of criticism. The idea that we have open, robust debate, that this is a marketplace of ideas, also requires voters to know who is spending and what they're trying to influence. So with that, I would ask, what this does is this limits that provision that closes the loophole to a pretty narrow set of time. People spend money. We know campaigns are year-round campaigns, especially bigger ones. People spend money all the time. Folks who are going to spend campaign communications, voters should know who they are. Members, I'd ask you to vote no.
Further discussion to the 822 amendment. I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker. You know, this is an issue that has come up every year, I think, since I've been in the legislature. And it has not gone anywhere every year since I've been in the legislature. And there's a reason for that. And the reason for that is, frankly, it's very subjective. And even the Campaign Finance Board has testified in the past that this is going to be difficult for them to manage. The other piece of this, now interestingly, there's been different versions of this language. The language in the current bill might be the worst version of this language, because in the past, we've at least had some recognition that there are groups that are going to be really negatively affected by this. This express advocacy language is going to probably bring in things like newspapers doing endorsements. They won't be able to do that. This is going to bring in voter guides from different organizations. They won't be able to do that. And we can say no, but frankly, in the past, the Campaign Finance Board testified that those groups would be looped into this, and that is how they would rule on this. They have testified to that in the past. So maybe they've changed their tune. Maybe they've changed the makeup of the board enough to get through whatever they want, but I don't think that's the case. I would also point out that in this amendment, there's a really critical piece, and that is that this express advocacy language would not apply during any period during which the legislature is convened in a regular or special session or during the 14 days immediately following. Let me tell you why that's important. Because when we are in session, there are lots of people who are trying to influence our vote. That's the whole point. But they're not trying to influence the public's vote. They're trying to influence my vote. And the public absolutely has the right to do that, whether it is through their own volition or whether they choose to use another group to do that. The public has a right to influence my vote. And this stifles that in a very dangerous way. We should absolutely support this amendment. Thank you, Representative Torkelson, for bringing it forward. This makes the bill better. I would encourage a yes vote.
Any further discussion to the A22 amendment? I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Torkelson, for bringing this amendment. These provisions that we're talking about, when we're talking about political speech, when we're talking about the core of our First Amendment, are areas where we, as the people, as the representatives who work for the people, should be very, very cautious. We should be very skeptical of use of the government, of government employees, of government enforcement mechanisms to go out into that free marketplace of ideas that exists out there and tell them what they can and can't say, to tell them maybe they shouldn't say anything, to tell them if you do say something, you're going to need to be part of a group that might have to disclose who you are. We're talking about the core of our First Amendment right, of each one of our constituents' First Amendment rights to get together as groups, to influence us at the legislature, and yes, to influence elections. That is the core political right of every single Minnesotan. It's in the First Amendment, it's protected in the First Amendment for a reason. And so as we're talking about regulating speech about legislation, or regulating speech about elections, we should be very careful, and thank you, Representative Torkelson, for going back to the importance of bright lines. We should be very careful to draw bright lines instead of fuzzy lines. And Representative Greenman, thank you for pointing out that this is the federal standard. As a fellow lawyer who dabbles some in campaign finance law, I'm sure you also know that there are multiple times in which the Federal Election Commission, which enforces the federal standard, 6 election lawyers, 6 of the most qualified election lawyers in the country, when they are trying to apply that federal standard after the fact, after people have spoken, have exercised their First Amendment rights, after the fact, those 6 highly qualified election lawyers split 3-3 on whether something meets this federal standard or not. Because it is a multi-factor balancing test that's decided after the fact by government bureaucrats. So we should be very careful about putting those kind of fuzzy lines into our laws when we're talking about the rights of the people to speak, the rights of those in the marketplace of ideas to speak about ideas and then try to hold us accountable as the people who work for them. They don't work for us. We work for them. So we in this body should not be telling them, hey, maybe you don't want to speak. Maybe you don't want to speak about legislation. Maybe you don't want to speak about legislators. We should be very, very cautious about doing that because the core of the right of the people to participate in our form of government is their right to participate in the free marketplace of ideas, and we shouldn't be trying to chill that by having a fuzzy multi-factor balancing test that they have to think about whether 2 or 3 years in the future, the members of the Campaign Finance Board, a majority of the members of the Campaign Finance Board will decide that the multi-factor balancing test weighs in favor of that they should have disclosed and filed a committee when their group of neighbors got together, or their community group got together and chose to engage in their core First Amendment right that all of us as Minnesotans, that all of us as Americans have to speak on fundamental matters of public policy and to speak and participate in our election process. So thank you, Representative Torkelson. This does make this provision a little bit better. It's still not as good as current law, frankly. It does make it a little bit better, and so I hope members will support it. Thank you.
Further discussion to the A22 amendment. I recognize the author of the amendment, the member from Brown, Representative Torkelson.
Well, thank you, Mr. Speaker, and thank you, members, for your support of my position. It's clear that there are First Amendment rights. It's clear that these definitions should also be clear. We should have bright lines so that people know when they've crossed the line. You know, there's a speed limit that says 55 miles an hour. It doesn't say, well, if it's, take your chances, it's 55 or it's 65. In this case, it's clear language is what's permissible and what's not permissible. You've already heard from others how difficult it is to enforce this sort of language that's in this bill and makes the lines fuzzy and invites court action, frankly. I think it's popular knowledge that this will probably be challenged in the courts. We'll be spending state money trying to fight it, and we will have a great challenge trying to clarify something that is so ambiguous. Please vote green on the amendment.
All those in favor of the A22 amendment, please say aye. Aye. Those opposed, please say no. No. The motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Torkelson moves to amend House Law Number 3, the 5th engrossment as amended. The amendment is coded A23.
I recognize the author of the amendment, the member from Brown, Representative Torkelson, to explain the A23 amendment.
Mr. Speaker, the A23 is another attempt to fix this problem in the bill, and this time we would eliminate express advocacy and replace it with the language regarding electioneering. Electioneering, at least, is something that's well defined. It's something that I believe if we had had bipartisan work in the Elections Committee and worked together, we could have come up with electioneering language that both sides of the aisle could live with. It has many of the same impacts as the language in the express advocacy portion of this bill and would make this bill just a little bit closer to being something that could be, potentially be, bipartisan if we were willing to work in a bipartisan fashion.
Any discussion to the A23 amendment? I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair. Members, I would ask you to vote no on this amendment. It does two things. And a piece of the second thing I like. You took my electioneering bill and you put it in your amendment, and I appreciate that. And it has a loophole carve-out that I oppose, and I'll talk about in a second. But I hope when we get the elections omnibus bill, where this electioneering language is, that we can have that conversation, and I look forward to your support on that provision. Here's the reason that this is a bad amendment. When we're talking about, what we're talking about now is not preventing the folks who are spending from spending. What we're talking about is disclosure. All we're talking about is saying, with the express advocacy provision, if you are running an ad that clearly identifies a candidate and uses the words of express advocacy, or when taken as a whole and with limited references to external events, can only be interpreted by a reasonable person as containing advocacy of an election or defeat of one or more clearly identified candidates, you have to file with the Campaign Finance Board and disclose. That's all we're talking about. Voters have the right to know who is spending money in our elections. That's what this does. I would also say on the second provision, on the electioneering provision, which involves a much broader set of communications that are currently not being disclosed at all. Those broader set of communications issue advocacy. What the electioneering provision does, and I appreciate the opportunity to talk about it, is that this is usually when we see like last minute, late breaking, right before the election drops. If it clearly identifies a candidate, if it's targeted towards that constituent and it's a candidate within 30 days of a primary or 60 days of the election, you have to disclose. But what this bill does, and what this amendment does, is say, if we happen to be in session, you don't have to disclose. If there's an ad targeting, if you're a candidate, if there's an ad targeting you, be it 60 days or 30 days before the election, to your constituent, and we happen to be in legislative session, voters don't have the right to know who's doing that, who's spending. Members, I would ask you, currently in this bill is the express advocacy provision. The electioneering provision is in our omnibus bill. These are both really important provisions for ensuring that Minnesotans know who is spending money to try to influence their vote. Members, I'd ask you to vote no on this provision.
Further discussion to the A23 amendment. I recognize the author of the amendment, the member from Brown, Representative Torkelson.
Well, thank you, Mr. Speaker. This amendment clearly improves the bill. Please vote green.
All those in favor of the A23 amendment, please say aye. Aye. Those opposed, please say no. No. The motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
New Brindley moves to amend House Bill number 3, the fifth engrossment as amended. The amendment is coded A27.
I recognize the author of the amendment, the member from Chisago, Representative New Brindley, to explain the A27 amendment.
Thank you, Mr. Speaker. This amendment is actually very simple. There is a provision in the bill that will register minors to vote, 16 and 17-year-olds, to be able to pre-register to vote. This amendment will simply prevent that pre-registration for minors who have committed a felony. 3 weeks ago, on the House floor, I noted a memo. I had just literally, while we were sitting on the floor, I read a news article about a memo from Hennepin County Attorney Mary Moriarty. And in that memo, she noted changes that she was making to juveniles being...
Point of order, Mr. Speaker.
Representative Long, state your point of order.
Mason's 124 personalities are not the subject for debate. Mary Moriarty is not the subject of the debate. The subject of the debate is the A23 amendment.
Representative New Brindley, please confine your remarks to the A27 amendment without evoking personalities of specific individuals. Representative New Brindley.
Thank you, Mr. Speaker. And I would rise to a point of order, and I would note that, frankly, talking about actions and policies of an individual is not invoking personalities. However, under Mason's Section 61, it requires interruptions to be made in good faith and not to harass the speaker. It is in Mason's. So, I will go on. Just 3 weeks ago, Hennepin County Attorney Mary Moriarty put out a memo. Now let me tell you
Point of
about
order,
that
Mr. Speaker.
memo.
Representative Long, state your point of order.
Mr. Speaker, I've tried to be real clear, but Mason's Manual, Section 124, Paragraph 1, in debate, a member must confine remarks to the question before the House and avoid personalities. It is not the person, but the measure that is the subject of debate, and we need to be focused on the subject of the debate and not people. Thank you.
I'm going to defer on ruling on this point of order one more time. Representative New Brindley, please review Mason's 124, paragraph 1. In debate, a member must confine remarks to the question before the House and avoid personalities. I'm going to give you one more chance. Please confine your remarks to the A27 amendment without evoking personalities of individuals. Representative New Brindley.
Mr. Speaker, point of order.
Representative New Brindley, state your point of order.
In Mason's Section 61, it is common practice to permit a member to be interrupted to ask questions concerning points made during a speech if the interruption appears to be made in good faith. Interruptions may not be made to harass a speaker.
I find your point of order is not well taken. Representative New Brindley.
Mr. Speaker, point of order.
Representative Davis, state your point of order.
Mentioning a name is not bringing in personalities. I would suggest we let Representative New finish her speech here. Just because she mentions a name isn't a personality issue. So
Representative Davids, please cite the rule or section of Mason's under a point of order. We're not offering advice on a certain point of order.
61 or 124.
Representative New Brindley has the floor as we're debating the A27 amendment.
Mr. Speaker, I was rising to point, I think it was 124. But yeah, Mr. Speaker, just let her talk. Come on.
Again, Representative New Brindley, you have the floor. Please confine your remarks to the question before the House, the A27 amendment, and avoid evoking the personalities of individuals. Representative New Brindley, one more chance. Please confine your remarks to the question before the body.
Mr. Speaker, point of order.
Representative Koznick, state your point of order.
Mr. Speaker, I rise under Section 94, the right of a member to hold the floor. When a member has been recognized, it is a breach of order for another member to interrupt, except for the purpose listed under Section 92. The majority leader continuously is interrupting speakers under a vague ruling of personalities when Representative New Brindley is simply using somebody's name, not their motives, and the speaker should remind the majority leader interruptions are not appropriate.
Representative New Brindley, you have the floor.
Thank you, Mr. Speaker. I assume that the Speaker is not going to rule then on that point of order. Once again, there was a memo put forward 3 weeks ago. In that memo, it became the policy of the Hennepin County Attorney's Office to...
Mr. Speaker, point of order.
Representative Long, state your point of order.
Mr. Speaker, the member referred to the Hennepin County Attorney's Office. The amendment that we have here before us deals with 16 and 18-year-olds with felony convictions from pre-registering to vote. That is out of order under Mason's 124 because it is dealing with personalities, and is out of order under Mason's 101 because it is not confining the debate before the question before the body, which is the A27 amendment dealing with felony convictions and pre-registering to vote, and not individuals outside of this amendment that are not named in the amendment.
I will request advice on this point of order. Representative New Brindley, perhaps if you could lay a foundation for your remarks and why this is important to the 827 amendment.
Thank you, Mr. Speaker. As it turns out, that's what I would do if I was given an opportunity to speak. But I have yet been given an opportunity to speak. This is, honestly, folks, I'll tell you what, we can do this all night long. The irony, of course, on this amendment is that I was going to speak to it and withdraw it. But I think now, Mr. Speaker, I will ask for a roll call on this amendment.
Representative New Brindley requests a roll call vote on the A27 amendment. We are still under advice on Representative Long's point of order that your remarks are out of order under Mason's 124. Representative New Brindley, if you have advice to offer.
Thank you, Mr. Speaker. This is directly related to the policy regarding juveniles. And this, the point that I am trying to make is directly regarding policy regarding juveniles and relates directly to the bill as it relates to registering juveniles to vote. These are not hard dots to connect.
Any further advice? I recognize the member from Stearns, the minority leader, Representative Damath.
Mr. Speaker, advice to you as you decide to rule on this. The behavior in this chamber is unacceptable. We have a member that is trying to explain and lay a foundation for an amendment to a bill that the majority clearly has the votes and intends to pass. We have every right to have our member be heard, to lay the foundation, and to set that up for a vote, which we are now going to have a roll call on. Mr. Speaker, I ask that you would take my advice. Have it well taken. Thank you, Mr. Speaker.
I'm going to defer ruling on Representative Long's point of order. Representative New Brindley, please build a base for how your remarks are relating to the A27 amendment. Representative New Brindley.
Thank you, Mr. Speaker. Interestingly, I'm not really sure how to build a case when I am not able to reference a memo, when I'm not able to reference the policy of an office. Because there was just a point of order on raising a point about an office, the policy of an office. And I'm going to be very clear that that's what I'm saying here. This is the policy of an office. Not talking about a person, talking about an office. The policy of the Hennepin County's Attorney's Office, which was put forward 3 weeks ago, is that we are no longer going to hold juveniles accountable. Potentially for very violent crimes. That's what that memo was really very specifically about. A 15-year-old and a 17-year-old convicted of murder. Murder. Premeditated murder. And those juveniles are not going to be held accountable for that. They will not be tried as adults. Instead, their sentencing will be done in 2 years. They'll be on probation. And as we've already decided in this chamber, and by we, I mean the Democrats in this chamber, have already decided that we're not going to hold people accountable.
Point of order, Mr. Speaker.
Representative Long, state your point of order.
Well, I think Representative New Brindley knows perfectly well my point of order, which is House Section 124, paragraph 3, motives of a member. She was very clearly undermining and arraigning the motives of the Democrats, as she said very clearly.
Representative New Brindley, please continue your remarks without evoking the personalities or motives of members of this chamber. Representative New Brindley.
Correct. Oh boy, this is something else. It's going to be a long night. Because let me tell you, we got a lot to say about this bill. And frankly, I thought most of us wanted to be out of here at a reasonable time tonight, but apparently not all of us care about that. So, in this body, we passed legislation several weeks ago to not hold felons accountable when it comes to voting. In the state of Minnesota, we already, and frankly, I wasn't going to talk about any of this, but apparently we need to remind folks of what happened. Several weeks ago, I don't know, probably months ago at this point, session is a time warp, but legislation was passed to say that felons would now have the right to vote immediately, regardless of the length of their sentence. Because of course, in the state of Minnesota, we know, and it's a choice, that in the state of Minnesota, we have shorter than average prison sentences. We choose to not send people to prison, and instead, we choose probation as a form of holding people accountable in the state of Minnesota. So for a lot of us, particularly when it comes to violent crimes, like the violent crime of murder that I referenced from these juveniles just a few weeks ago, we actually don't think that's a great policy. We actually think that is a lack of accountability. And now, we're also going to register these folks to vote immediately. Immediately. And these juveniles will immediately be registered to vote and eligible with no accountability. With no accountability. That's where we are. And so this amendment is really quite simple. Like I said, ironically, I was going to speak to this and withdraw it. Because, frankly, I know we're not going to take the amendment. I didn't feel the need to belabor this point, ironically. But here we are. And so, boy, I sure hope folks have something to say about this amendment and the lack of accountability we've got. But the reality is, we are already choosing in this elections bill, in this underlying bill, to pre-register a ton of people to vote. Regardless of whether they ever intend to vote, we are flooding the voter rolls with new people. And I think it's reasonable to say that we should exercise a little caution with some folks. My guess is, frankly, a lot of these folks never intend to vote. But now we're going to say these juveniles convicted of felonies, maybe we should at least put a pause on that. Maybe we should at least put a pause on that and say when those folks have served out their time, they can register to vote just like everybody else. Everyone has the right to register to vote when they are eligible voters. But that's not what this does. And I want to be clear about why that's a big deal and why that's a big deal for folks who are involved in elections. So voter rolls are public data. When you register to vote, that is public data. And anyone in the state of Minnesota can go to the Secretary of State's office and purchase that. I did it several years ago on a CD-ROM. Now, frankly, that data, you still have to be able to translate that data, and it's above my head, frankly, the technology behind it. But anyone in the state of Minnesota can purchase that data. And frankly, it's not very expensive. I think when I purchased it several years ago, it was like $45. It was cheap. I don't know what the price is today, but it's cheap. That data is available to everyone in the state. But here's the trick of it. For people running elections, unless someone is registered to vote, you don't have access to their personal data. You don't have access to their information. You don't have access to their home address. You don't have access to email addresses or phone numbers or whatever information is going to be made publicly available. You don't have access to that until they are registered to vote. Or, frankly, until you purchase that for ungodly amounts of money from a third-party vendor who's willing to sell anybody's data, which we should also be very concerned about. However, when we flood the voter rolls with all these pre-registrations of 16 and 17-year-olds, when we flood the voter rolls with registration anytime somebody interacts with the DMV, anytime someone interacts with Health and Human Services, we are flooding the voter rolls with data. And in fact, by registering 16 and 17-year-olds in the state of Minnesota, that means we are effectively registering every Minnesotan who matriculates into adulthood in this state. We are making public the data, that private personal data, names, addresses, age of every single person entering adulthood in the state of Minnesota. This is alarming. Now, that's what's happening in the underlying bill. My amendment, again, so simple. It simply says that 16 and 17-year-olds who have been convicted of a felony, we're going to put a pause on that. We're going to wait on that until those folks have worked out their sentence, and frankly, until they turn 18 years old. If they're a felon in the state of Minnesota and they're not in prison, as soon as they turn 18, they can register to vote. But let's just put a pause on it and let it last that long. This is a no-brainer of amendment, so I would recommend a yes vote.
Is there any further discussion to the A27 amendment? I recognize the member from Hennepin, Representative Frazier.
Thank you, Mr. Speaker. And Representative Brindley, I look at this amendment and I also take stock in what I'm seeing happen around the country. And in large part, I'm taking stock in this constant narrative or movement toward limiting who will have the ability, or putting barriers in the way of who would have the ability to participate in our democracy, or our constitutional republic, as some folks like to say, right? Who's going to participate in this process, participate in the franchise to elect their representatives? And I'm seeing this movement against our young people that I don't really understand. I often say the youth will be our salvation. I say it all the time. For those that know me, they hear me say it. I tweet about it, put it on Facebook. I put it out there because I truly believe that. I'm a father and I have young people in my household, and I tell them all the time, you are the future and you will save us. So I don't understand why we have this constant movement to put barriers in the way of our young people to get involved in a process that's foundational to our democracy, or constitutional republic, as some people like to say. I don't understand that barrier. Now I'm going to get to the amendment until there was a reference to the restore the vote that we passed off this House floor and off the Senate, and now we've given thousands of Minnesotans their right to participate and their voice back to our democracy again, which is a good thing, especially when I talked about the historical pieces to why we have those felony disenfranchisement laws all over this country. What I say to this amendment is that there are no carve-outs in the restore the vote bill that we passed off this House floor and out of the Senate. There should be no carve-outs to our young people. There should be no barriers put in place to our young people to prevent them from participating in this democracy, or constitutional republic, as some of you all like to say. Do not put barriers in front of our young people that want to participate and have their voices heard. And then just to clear up some technical pieces, for these individuals that pre-register, they will not be on the voter rolls. Their data will still be protected. We will not have access to it. But we do know when we have pre-registration, it does encourage and it does increase participation in this thing we call democracy, or constitutional republic for some of y'all that like to say that. Do not put these barriers in place. So I would urge a no vote on this.
Further discussion to the 827 amendment. I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. I didn't see and haven't seen a notification of the change to SOP, which says that an action recorded in our House Journal is actually called a motive. And I thought if it's in the House Journal, it's valid for the floor. So when we take testimony here and we talk and discuss arbitrarily calling an action that's actually recorded in our House Journal as a motive is just basically saying, I don't want to hear you speak. And Representative Knorr, I want to hear her speak. Or New Brindley. I'm sorry, Representative Knorr. I'm flustered by this because the redefinition of words should be spread to all of us so that we know. And is it universal that any action is automatically a motive? I think not. So unless you're going to officially change it and notify all of us here, please stop calling an action a motive, because they're different. And when we're listening to the debate on this, stop disregarding the testimony of our members, because it's not just myself or anyone else that stands up here and speaks. It's not just us. It's the people in our district. I frequently get texts and emails about what we're debating as we're debating it. And to silence people arbitrarily is silencing their constituents, which isn't protecting democracy one bit.
I recognize the member from Anoka, Representative Scott.
Thank you, Madam Speaker. And Representative New Brindley, thank you for this amendment. I don't know how much more logical we can get. If someone has been convicted of a felony, if they're underage, we should not be allowing them to vote if they have not served their sentence under the new law that was passed, a few weeks ago. It is a felony to illegally vote. You would think that someone, in the example Representative New Brindley gave of a minor committing first-degree murder, you can't get a worse felony than that. Why would we think it's okay to allow those people to vote? I don't understand the lack of logic that would cause someone to vote against this amendment. I bet if you polled people out on the street passing by, if they thought that a 16-year-old that's been convicted of murder and is filling their sentence right now, if you think that person should be able to vote, I'll bet you 9 out of 10 people on the street would say, well, of course not. I don't understand. I don't understand why this is a problematic amendment. It seems like, why would we need a roll call for this? It should be a unanimous vote. But yet we're making all kinds of felonies in our voting laws when you illegally vote, but yet we're going to allow someone that potentially committed murder to vote. Help me understand. Somebody please help me understand, because I don't get it. Vote green on the New Brindley amendment.
I recognize the member from Hennepin, Representative Robbins.
Thank you, Mr. Speaker. I rise in support of the New Brindley Amendment. Contrary to some of the
remarks that were made a few minutes ago, this is a very narrow amendment. So this is not stopping all 16 and 17-year-olds from pre-registering to vote. It's a very narrow focus. So all it does is say 16 and 17-year-olds who have been convicted of a felony cannot pre-register to vote. That's all it says. It's not taking away the opportunity to pre-register from any other 16 or 17-year-old, anyone who's even been accused of a felony or charged with a felony, just anyone who's been convicted of a felony. It's very narrow, it's common sense. I'm sure all of Minnesotans would support this, except maybe a few in this chamber, and I urge a green vote.
I recognize the member from Stearns, Representative O'Driscoll.
Well, thank you, Mr. Speaker. I was wondering if the maker of the amendment would yield to a question. Representative New Brindley?
She will yield to a question. Representative O'Driscoll.
Thank you, Mr. Speaker and members. Representative New Brindley, you and I have served together a number of years on the Elections Committee here in the House. And I'm almost afraid to start building a base on here for fear I might be called out under Masons on this, but I'm going to try anyhow. And I think I can be okay on this. When you and I were on this committee with Representative Nash, as a matter of fact, Representative Ray Dean was the chair of that committee, and Representative Ray Dean was a very big proponent. As a matter of fact, he was on the floor the day that we had the conversations and discussions relating to the exoneration of felons and being able to vote if they were quote-unquote off paper relative to their crimes and their convictions. And I know that he was very concerned about the confusion that could have arisen as a result of the conversations that people were having, and should I be able to register to vote and shouldn't I? And we had folks who talked about individuals who might have been charged. So Representative Brindley, I'm going to ask you the question I'm going to ask you is this. A 16 or 17-year-old who under law is not considered an adult would register to vote, could that create some problems for that individual as a result of confusion that we heard about over the years in committee? Does this help or hurt what the majority has done earlier this year related to felony voting?
I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker, and thank you, Representative O'Driscoll. And frankly, thank you for bringing up Chair Dean, one of the most good-natured, respectful chairs I've ever worked with. So as far as the confusion that this might cause, and I'm not entirely sure that I understand the question, but I'll do my best. If this goes into law, and presumably it will, all 16 and 17-year-olds will be registered to vote. Now, as I believe it was Representative Fraser indicated, that won't be public immediately, and that's true. Their information will not be public immediately. It will be made public the day they turn 18 years old. That information is public the day they turn 18 years old. So every single person who becomes an adult in the state of Minnesota will have their personal information made public on the day that they turn 18 years old. Of course, I think that, to your point, to confusion, certainly when 16 and 17-year-olds hear, oh, hey, they're registering me to vote, I can imagine some confusion with that. I can imagine some confusion with a 16 or 17-year-old saying, oh, hey, they just passed a law that I'm registered to vote now. And they might want to show up at the polls and vote. And maybe they get to the poll and they say, oh, I don't have, I'm not on the list, I guess, but they told me that I'm being registered to vote now. So, hey, my mom's here and she'll vouch for me, because we can vouch too. We can just vouch for each other if we live in the same precinct. So it doesn't have to be your parent. It could, let's say it's a 17-year-old and they're with their buddy who is 18, and their 18-year-old buddy is in the rolls, but their 17-year-old friend is not yet in the rolls. But hey, they know that we're registering them to vote now, so they should be there. Yeah, I can see how that might cause some confusion. and some inadvertent problems with young people at the polls and that 18-year-old friend vouching for their buddy. Yes, I can absolutely imagine that this would cause some confusion.
Representative O'Driscoll.
Well, thank you, Mr. Speaker. And Representative Brindley, thank you for the explanation, because I view it very similar to the way that you do. As a matter of fact, something that could be very confusing, and I mentioned on the House floor, that from time to time when I go to vote, because of my family's national origin and having punctuation in my name, that I oftentimes am not able to be easily found in the voter roll. And it makes the people in my district and at the poll very uncomfortable, because it's like, well, we know who you are. We grew up with you. We watched you grow up from little on. What do you mean you're not in there? And you're our state representative and you were our mayor before then. It's like, what's going on here? And the Secretary of State and I have had some conversations on that. I hope I can say Secretary of State that I didn't violate any rules by saying that. But he and I did have a direct conversation on a couple of occasions on that. And so here's the other thing that I find kind of interesting. So if I'm a 16 or 17-year-old, I'm kind of confused, maybe just got my driver's license. What happens if I'm emancipated? Now I believe that I can go ahead and vote because I had been registered when I was 16 or 17. Emancipated means that the law now views me as 18 years of age. I go in there and I say, well, Representative O'Driscoll was on the House floor, and he talked about how the fact that his name didn't show up in the polls, the polling books, maybe that's why my name didn't show up in here. Are we actually looking for more problems, or are we solving more problems? I think we're creating more problems that will be worked out in the courts, unfortunately, and at the expense of the taxpayers to try to defend laws that really we don't have to be creating or making available here today in this chamber. So, members, the New Brindley Amendment is a common sense amendment, a green vote, and it's going to be on a roll call. And again, Representative New Brindley, I really remember when you said, I was going to offer, discuss, and withdraw, but apparently there is some angst on this, so we're going to kind of find out where people stand on confusion with minors today. So I thank you for offering the amendment, and I encourage a green vote on the New Brindley Amendment. Thank you, Mr. Speaker and members.
I recognize the member from Dakota, Representative Koznick.
Thank you, Madam Speaker. Members, I think this is a well-found amendment to limit pre-registration to those that aren't felons, under the fact that when you're 16 or 17, you don't have an actual regular driving license. You have a provisional license, and you have a provisional license to make sure that you are able to drive responsibly. And I had it up here, but here I do have it here. If you, and I actually ashamed to admit this, but from experience, when I was a young driver, I wasn't a very good driver. And I went over the speed limit a couple times, got tickets. My parents were not pleased at all. I had a little fender accident with another driver, passing them on the right side of the road. I was not a very good or responsible driver. And I got this letter from the Department of Motor Vehicle Services that if I had another moving violation because I had a provisional license as a 16 or 17-year-old, that I may get my license suspended and revoked. And under 169.A, the driver's licenses that would register people under this bill, the commissioner should not issue a provisional or regular driver's license to a person whose provisional driver's license was revoked for conviction of a juvenile of a violation of certain motor vehicle violations cited in there. And then they would have to go back and take the driving course over. They would have, to the satisfaction, they would get their license removed until they're 18, and then they would also have to complete a formal course in driving. They would have to complete additional 3 months of experience of driving. They would have to complete the written examination of a driver's license with a passing score, and then also comply with all other laws for reinstatement of a provisional or regular driver's license. And so when you're 16 or 17 and you have a provisional driver's license, This amendment makes sense that if you've also committed a felony, maybe we should tap the brakes. If we don't trust them to be on the road and they've committed a felony, maybe we should just pause here. We're not taking their right to vote away because they can't vote until they're 18, but this is just a common sense provision amendment that taps the brakes and says, we're not going to register you to vote based on your other violations as serious as a felony. And so, members, I think it's quite important that this simple provision be put in there and that we are debating it. Previously, there was a little skirmish on the House floor about the procedures that we operate under, but we should be here. Members have a right to debate the bills. They have the right to do that without being interrupted. And I'm glad we're having this further debate about that, and I hope that we can continue to have a debate about the A27 amendment and this bill without being interrupted, and to have a full and honest debate about it and not interrupting repeatedly speakers. So I hope that that part is now understood, and we can do the business of the Minnesotans and have a good debate. But 16 and 17-year-olds that have a provisional driver's license and commit a felony shouldn't be allowed to automatically be registered to vote until they get their orders, everything in order in their life there. So thank you, Representative New Brindley, for bringing this amendment. I hope that we will find this in good order, and I'll be supporting common sense and upholding the integrity of our elections is really what this does. Representative New Brindley, Representative Greenman, we've talked a lot over the years as you've worked on this bill that part of voting laws should be bipartisan and should uphold the integrity and confidence of our elections. But when you have felons being that aren't even yet of age to vote, we shouldn't be registering them to vote.
I recognize the member from Martin, Representative Olson.
Thank you, Mr. Speaker. And to everyone in the room who doesn't quite know this, I spent a number of years as a social studies teacher, and my job as a social studies teacher was to get students prepared to vote when they turn 18, much like what I believe the intent of this original portion of the bill would be. You have 17, 16-year-olds getting pre-registered to vote. That's in order to prepare them for their future civic duties, all the things that I was attempting to teach my students to be good citizens. But let's be real here, members. When you have an individual who's committed a felony, when you have a minor, a juvenile who's committed a felony, like let's imagine maybe murdering a 23-year-old in their apartment, and that individual strikes a really great deal or is offered a spectacular deal that would only include about 2 years in a juvenile delinquent center, I think that is an issue, and I think that is a problem, and I do not believe that that person is ready to vote. I don't think that that person has been properly prepared to do their civic duty, something that I was trying very hard for a number of years to provide my students with the ability, the knowledge, the know-how. Here's what we need as citizens of this great state and citizens of this great nation. You should be prepared. We need to prepare our students to do this, but in no way, shape, or form should an individual who has a felony charge, who has been charged with this felony. We're not talking about someone who doesn't. We're not talking about a 16-year-old who is going through their junior year. They just started junior year and they're excited because there's the winter formal. We're not talking about that person. We're not talking about a 17-year-old, someone who's just entering their senior year, or maybe they're all excited about where they're going to go to school after they graduate. That is not what we are talking about here. We are talking about individuals who committed a crime. Individuals who are 16 or 17 years old, who have committed a felony. People who have gone outside of our society and they've broken the rules of our society, the way that our society has been built on laws. They've gone outside of that. They have broken those rules. They've broken those laws, but they haven't just broken them a little bit. Oh, you know, high schoolers, it's high school, right? They didn't just go out and have a good time. They went into a person's apartment, hypothetically, and murdered them when that person was only 23. Something like that. And then you have an attorney who's, they didn't mean to, or something. I don't know. I'm not imputing motives here. I don't know why. But if they've committed a felony, they should not be allowed to vote the next day. They should not be pre-registered to vote the day after that. They should not be able to accumulate or hold on to the rights that we law-abiding people who fulfill our duties to society and sit within that society have. They are not prepared for it. Our job is to prepare them. Maybe that's why there are rules. Maybe that is why there are consequences to actions. Maybe that's why we've set this up. So if you do in fact prove that you are not capable of fitting within our society and working according to our rules, maybe there should be some consequences. One of those consequences should be that you cannot pre-register to vote. I think that that's a little bit to ask, just a little bit. And I think it's quite reasonable for us to ask that our individuals, our minors, those of us who it was said over there, they're our future. I think it's reasonable to expect that our future fits and is prepared to perform society in a way that fits at least the law. We want our people to be good people. We want our citizens and our young people to be good. We want them to fit within society. We want them to move our society forward in a great way. We know that they are the future, but if you prove that you cannot do that, you should not be able to pre-register to vote, folks. Now, I was gonna start just naming names and just seeing how far I could go, and maybe I talk about Abraham Lincoln, maybe I talk about George Washington, just start talking about names and see how long it would take before motives were impugned or someone were to stand up and question whether or not I was fulfilling some obscure rule within Masons. But understand, members, that the custom and usage of the House here allows you to say people's names. You absolutely can do that. And I think it is incredibly embarrassing to this establishment when we attempt to shut down other people's conversations because they say a human being's name. It's not even a fanciful name. It's not even a person that's been drawn up or imagined. It's a real person's name, an event that really happened. And I think that that is very shameful when we attempt to stop individuals from talking because they don't like the name that was said. I think that is a true embarrassment to the way that we run this House. And I hope that in the future, we will refrain from doing those sort of things. Thank you, Mr. Speaker.
I recognize the member from Wright, Representative Hudson.
Thank you, Mr. Speaker. Members, if there are any among you who wish I would speak less, you can thank Representative Olson because he largely stole my thunder. We didn't even share notes, but every point he made was a point that I was going to rise to make. All I will add is that we're not just talking about the commission of felonies. We're talking about felony convictions, which aren't found in a Cracker Jack box. You don't trip and fall and get up with one. We have an entire process that is very well thought out, that is very well adjudicated, that sometimes results in a felony conviction, which means you have been found guilty beyond a reasonable doubt of violating the public trust in the most severe way we have to describe it on the books. So maybe, under those circumstances, maybe you shouldn't be able to pre-register to vote. What a horrendous consequence for, hypothetically, killing somebody in their own apartment. I mean, that's the thing. To the extent that we're going to make the argument that felony status is somehow being a victim, you've been victimized by being convicted. I don't know how that happens. I don't know how the moral math on that works, but that seems to be the way we're talking about it. to the extent that we want to ensure that we're not punishing people too much, I think we might be splitting hairs when we come down to pre-registration to vote. If we can't say that not being pre-registered is too much of a consequence for violating the public trust to the degree of a felony, I think we might have entered the realm of the absurd. Thank you.
I recognize the member from Carver, Representative Nash.
Thanks, Mr. Speaker. So I don't like the notion of the pre-registration to start off with, because I have registered to vote a number of times in different states that I've lived, and it was not exactly an onerous event. I didn't have to break a sweat. I didn't have to work hard. I went in and said, I'd like to vote, and I'm 18 and I can do that. But that's another part of the conversation. Representative Brindley, here's what I like about your amendment, is that it is a proactive, preventative measure that says, as Representative Hudson just said, if a person is convicted of a felony, then they cannot be pre-registered to vote. And I think that's what Representative New Brindley was trying to get across in the beginning of her presentation of the amendment before she was interrupted persistently, irrelevantly. But this is a preventative measure. Why would we not want to accept an amendment that was going to put into statute a provision that says if this person commits a crime, is convicted of the felony, and they happen to be under the age of 18, then we should not pre-register them? Wow. Wow, so hard. Let's not do that because we're going to somehow disenfranchise them. That we're going to encumber them with something so onerous that they're going to suffer some great harm after they've been convicted of a felony. Wow. Certainly, we don't want this amendment to go on, Representative New Brindley. This is just, dare I say, well, I won't say it, but why would the majority not want to put this piece of guardrail into the bill? Is it because you don't want any edits to your bill? Because you think that it's so divinely inspired that this is the bill? Representative New Brindley's amendment, as I had said, is really not, it's not a gotcha amendment. It's saying that if a person who, if this bill becomes law, and I really hope it doesn't, but if this bill becomes law and we're going to pre-register people who are under the age of 18 and they commit a felony, then we should not let that happen. Once again, wow. New Brindley brings another gotcha amendment. Good job. Why are we being so obtuse to the notion that if you're committing a felony and have been convicted of such, that you shouldn't have the benefit of being pre-registered to vote? You know, this is a very strange place, but I try to apply some logic to it. And I can't find the logic in denying this amendment. I can't. I've thought about it. To me, when I read this, as I was preparing for the floor today, I thought, well, this is a no-brainer. Of course we would put that on. If a person commits a felony, then, one, while they're still under the punishment phase or in jail, they shouldn't be able to vote. But you shouldn't be able to pre-register to vote if you've been convicted of a felony. Once again, wow. Perhaps one day I can sit down with some of you over an adult beverage or a cup of coffee and have you explain this to me, how you arrived at this offensive behavior that we're exuding over here, that you don't want to take this amendment. Because I'm not seeing it. Once again, this is a preventative measure. Because this will happen. We saw that it happened recently in Hennepin County. That this type of behavior did happen of people who were underage, and once they're convicted of this felony, now that the Attorney General will be prosecuting that case, if your bill goes into law, and once again I hope it doesn't, they can be pre-registered to vote. Huh, okay. Well, again, Representative Brindley, I appreciate the amendment. I'll be voting green. I hope everyone's going to be voting green, because I hope you're finally convinced after all of us, and I think a few more, try to make the point that this is not something that should create great offense, that we should all agree in a Minnesota House of Representatives kumbaya moment that we say, yeah, you know what, let's not pre-register the 16 and 17-year-olds who have committed a felony. Members vote green.
I recognize the member from Hennepin, Representative Kraft.
Thank you, Mr. Speaker. So this portion of the bill is one that I carried, pre-registration, and I am very excited to talk about it a little bit later. I'm really disappointed that this has been the thread of the discussion about it. I'll be really simple about this. We debated and passed Restore the Vote a while ago. And now what this is saying is that we're going to treat those under 18 differently, that they're different. That's not the message that I want to send, and so I ask you to vote red.
I recognize the member from Hennepin, Representative Elkins.
Thank you, Mr. Speaker. Just very briefly, I think that if there's impatience over here, it's largely because this amendment is completely superfluous. Every voter registration application, regardless of the applicant's age, goes through a rigorous vetting process through the Secretary of State's office, and that vetting process includes a query off to the Department of Corrections system with a very simple question. Is this person an incarcerated felon who is not currently eligible to vote? And if the answer to that query to the Department of Corrections is yes, this person is a incarcerated felon who is not registered to vote, then that person is not added to the voter rolls, regardless of their age. This amendment is completely superfluous.
I recognize the member from Stearns, the Minority Leader, Representative Damath.
Thank you, Mr. Speaker. And as we have debated this, Representative New Brindley, thank you for bringing this forward. I know we had discussions, and this amendment was going to be brought forward. And again, just to remind the body, the wording of this, notwithstanding paragraph A, an individual has been convicted of a felony, must not be permitted to pre-register to vote. We knew it was an important amendment, but like was already mentioned by the amendment author, it was going to be offered and withdrawn. We just wanted to make the point and withdraw it. Unfortunately, as our member was trying to lay the groundwork and was continuously almost ruled out of order, but definitely there was a rising to a point of order. She was interrupted a number of times. That is not how we do business in this chamber. So I really appreciate the fact that we have had more time than we ever anticipated to discuss this particular amendment at length. Because instead of offering it, withdrawing it, and moving on, the public, who doesn't always follow what we do very closely, but the public is having the opportunity to learn more about it. Now, with that being said, a 16 or 17-year-old that has been convicted of a felony should not be given the offer to pre-register to vote. And so with that, we know that the board on this roll call for the amendment that is not withdrawn now, but on this amendment will be green, because we would not want to disrespect the families of the victims of these criminals. As was said earlier in this chamber, that young people, they're our future. We don't want to give them any barriers to participating in democracy. Well, what I can tell you with that is young people, first of all, have to be responsible for their actions. And if they choose to commit a felony, they don't need to pre-register to vote. We can help young people be productive members of society by helping them understand the responsibility of being responsible for their actions. Also, if they have not chosen to commit a felony and are not convicted of that, we can help them go through the process of learning to pre-register to vote, not an automatic attachment to their driver's license. You've seen a number of things being circulated around the chamber. You've seen articles on current events in the state of Minnesota that were referenced, but apparently we can't reference some of the specifics on these articles, and I won't do that because I don't want the majority leader to have to rise to a point of order on me. But you've seen a memorandum come out, you've seen 2 news articles. I would suggest that as you're getting ready to vote on this amendment and vote green on it, you would see that the worst thing that can happen is when we disrespect the victim's family, because there is a victim that is not going to be able to vote. Yet under this, if you vote against this amendment, you would empower those that actually are going to be convicted felons. You would empower them to be able to pre-register to vote. So with this amendment, please vote green. That would prevent any convicted felon from being given the opportunity to vote. Thank you. Thank you, Representative New Brindley, for bringing this through and not just withdrawing it and giving us the opportunity to vote on it.
I recognize the author of the amendment, the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker. And before I start my remarks, I believe I may have asked for the roll call at a time when it was not recognized. Do we have a roll call on this amendment?
Representative New Brindley, you requested a roll call, and I saw 15 hands. There is a roll call on the A27 amendment.
Thank you, Mr. Speaker. I just wanted to verify that. Thank you for the rigorous debate, and thank you for all the comments from my colleagues. I was particularly struck by our leader, Damith, just now, who said there is a victim who will not be able to vote. And that's exactly right. As we debate this, we are talking about juveniles convicted of felonies. And I have referenced very specifically a memo that came out just a few weeks ago that was precipitated because of 2 juveniles who are not going to be tried as adults. They will not serve prison time. But they are felons convicted of killing a woman, premeditated murder. That woman will never vote. She will never have that opportunity, nor will her family have the opportunity to spend another second with her. But boy, those kids, we're going to register them to vote. That 15-year-old and that 17-year-old, we're going to register them to vote. Now, ironically, it's not just me that thinks that this memo, that this policy is a problem. I had a couple of articles passed out so that you can see this is not just me. These articles came out, I think they're both the same day, on April 9th, around that time. Oh, one of them's from April 5th, one of them's from April 9th. But they make it very clear our Attorney General said that that was the wrong call, this memo from the Hennepin County's attorney's office. It was the wrong call. And he said, I agree. I'm quoting directly from the article. I agree with the family.
Representative Vang, state your point of order.
That the disposition
Mr.
of
Speaker,
the county attorney
the member has mentioned the Attorney General's
Speaker,
name,
point of
and
order.
it is very clear under Mason's 114 that mentioning the executive or another official is dealing with character or conduct, and the subject of the debate is the matter before us in the amendment and not the executive or other official.
Mr. Speaker, point of order.
Representative New Brindley, please continue your remarks, confining them to the question before the body.
Mr. Speaker, point of order.
Representative Nash, state your point of order.
Mr. Speaker, point of order. I rise under Mason's 122.3, a member who resorts to persistent irrelevance, to persistent repetition after the attention of the House has been called to a matter may be directed to discontinue the speech by the presiding officers. The majority leader has gotten up again and again and again and again because he doesn't want to listen to Representative Ann New Brindley. That's all. She had the floor, well within our rights. 124 doesn't talk about outside, it talks about members here. And he stands up and interrupts one of our valued members again and again and again, and it is persistently irrelevant, intended to quelch speech and debate here on the floor. I would ask you to find my point of order well taken.
Representative Nash, I'm going to defer ruling on your point of order and give the floor to Representative New Brindley.
Thank you, Mr. Speaker. Where was I? I agree with the family and the community that the disposition the county attorney has proposed for this juvenile who was the shooter in this heinous crime is inappropriate. It's inappropriate. Those are not my words. This is what I think is really interesting, though, and I think this is what we have to keep in mind for the future. You know, this case has been, the Attorney General requested that this particular case be turned over to his office. He requested that power from the governor. But this is what I think is interesting. He said the governor's power under state law to assign criminal cases to the Attorney General has been used and should be used very sparingly. And I do not expect to make a request like it again. And that was said last Thursday. So my concern here is that while this particular case is going to be taken over by the Attorney General, he's also made it very clear that he does not anticipate
Point of order, Mr. Speaker.
Making that
Representative
request
Long,
again.
state your point of order.
Mr. Speaker, I really would rather not do this again because I have been very clear about the line, but right now we are talking about the character or conduct of a member that is an executive, and under Mason's 114, paragraph 5, that is very clearly out of order.
Point of order, Mr. Speaker.
Representative Dameth, before we get to your point of order, I'd like to acknowledge Representative Long's point of order. Representative New Brindley, please continue your
Mr.
remarks
Speaker, advice.
without evoking, I'm not going to rule on this, I've heard enough advice. Representative New Brindley, please continue your remarks without reflecting upon the character or conduct of a member or upon a member of the executive. Representative New Brindley, you have the floor.
Thank you, Mr. Speaker. So again, we are in a situation where addressing this particular case has been taken away from the Hennepin County Attorney's Office and has been assumed by the Attorney General's office. However, it's also been made clear that that's not going to be the standard. That it is likely that that request will never be made again. Will never be made again. And so while the juveniles in this particular case, the 15-year-old and the 17-year-old who committed premeditated murder, while it may turn out that they are prosecuted as adults, will serve time for premeditated murder, and I assume that all of us can agree that someone who commits premeditated murder should be held accountable for that. If you have committed premeditated murder, surely that is the one circumstance where we can all agree prison time is warranted. Accountability is warranted. But it has been made very clear that that is not going to happen in the future. And according to this memo, there are only 2 people in the city, in Hennepin County, in all of Hennepin County, who will be able to approve adult certification. And those are not judges. Those are not our judges. And when that happens, it's just going to happen. When another juvenile commits premeditated murder, they will not be tried as an adult. Those are not my words. That's from the Attorney General's office. That's where this is coming from. These are not my words. These are not my policies. I didn't do this. And I'm so sorry that you're uncomfortable having this conversation. But when folks are committing felony crimes, accountability is in order. And part of that accountability should simply be that we delay their registration to vote. My goodness, we can certainly delay their registration to vote until adulthood. This is not complicated. In fact, it's really easy. It's really easy. Just vote yes. This does not deny anyone's right to vote. Those 16 and 17-year-old felons, if they are not in prison when they turn 18, they can register to vote. This does not deny anyone a right to vote, except, of course, the victim. The victims have been denied the right to vote. This does not deny anyone else. This does not deny a juvenile convicted of a felony the right to vote. It doesn't. It simply delays their registration. It simply says, as part of this process, part of that accountability can be that we wait until they are adults. We wait until at least whatever meager sentence is handed out by Hennepin County is played out. It's not that hard. It's not that complicated. Just vote yes.
The clerk will take the roll on the A27 amendment. Would the clerk please call the name of the member who's voting remotely?
Hassan.
There you go. Hassan votes no.
Hassan votes no.
The clerk will close the roll. There being 59 ayes and 70 nays, the motion does not prevail and the 827 amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Quam moves to amend House Law Number 3, the fifth engrossment as amended. The amendment is coded A29.
I recognize the author of the amendment, the member from Olmsted, Representative Quam, to explain the A29 amendment.
Thank you, Mr. Speaker. And this is meant as a more of a technical cleanup and clarification and to get rid of some ambiguities. And it's basically, again, if you're pre-registered and you haven't voted, then you wouldn't be on, the data wouldn't be public. It restricts some of the access to just being distributed to the chairs of the major parties. And that's a general intent. We've been tweaking around in this area, and I thought a technical cleanup would be good.
Discussion to the 829 amendment. I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair, and thank you, Representative Quam, and I appreciate the conversation we just had. Reading this, it is much more than a technical amendment, and so I would ask members to vote no. We have lots of conversations about what data should be public and private, and there is our current law strikes a delicate balance to protect sensitive data on voters while providing transparency for Minnesotans. And what this bill would do is flip the presumption about public and voter privacy, assuming that all voter data is public, except for the specific provisions listed: voter date of birth, driver's license, identification number, military ID, passport, or Social Security. It also sort of has a conflict of, I think, given that we were talking about pre-registration, I think we all think it's really important that that data on 16 and 17-year-olds is private. That's in the bill. This bill, both when we got advice on it, both says it's public and then later says it's private. So with that, I think the conversation about what is public and what is private is a good one to have, but this bill does not strike that right balance, and I would ask members to vote no.
I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. And because the election system is a very foundation of our democratic republic, the presumption is that it should be as transparent as possible. What this does is maintain preventing if someone, because of threats to their well-being or their family, there's a system that we've been using to prevent that from being public. This keeps that. So protect what we need to, but the presumption is we have transparency. And that's what this is meant to do, transparency in our elections. And I hope for a green. Thank you.
Seeing no further discussion, all those in favor of the 829 amendment, please say aye. Aye. Those opposed, please say no. No. The motion does not prevail and the 829 amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Altendorf moves to amend House File Number 3, the 5th engrossment as amended. The amendment is coded A26.
I recognize the author of the amendment, the member from Goodhue, Representative Altendorf, to explain the 826 amendment.
Thank you, Mr. Speaker, and today I rise. Representative Greenman, I hope you consider this a friendly amendment. As I heard in your opening remarks when you were talking about your election bill and the importance of this election bill, I heard you say that we really need to protect Minnesota's elections and we need to pull it in. We do not need to have outside forces. I think that's a quote. We do not want outside forces influencing the Minnesota elections. So as of right now, I know perhaps both parties have received contributions from out of state. I also heard in election committees that, voters are tired of all of the propaganda that we get along elections time and all of the negative campaigning that's going on. And so I really believe my amendment is going to be offered to prohibit outside contributions coming from out of state, outside committees, outside funds, outside PACs, outside of Minnesota. And that is my amendment. I hope you realize it would be equal to both parties, Democrats and Republicans. And I agree with you. I agree with our committee. Voters are tired of the campaigning, the negativity, and this amendment would pull it in for both sides. And as you said, we want to protect Minnesotans, and we should have Minnesotans in charge of our elections. So let's stop the outside money coming in from out of state.
Discussion to the A26 amendment. I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker, and thank you, Representative Altendorf. I share those values. I share the values that we want to uplift the voices of Minnesotans. Unfortunately, this tool has been taken off the table constitutionally. We can't, what this would do is limit citizens outside of Minnesota from contributing, and that is unconstitutional. We can prohibit donations from foreign nationals, but we can't prohibit the First Amendment rights of contributions from citizens. So we are actually, and I think what we want to do is, and I look forward to the continuing conversations in both this bill and as we go forward in the omnibus bill, because we have heard several proposals about things that we can do, legally we can do, to center the voices of Minnesotans, to encourage small dollar contributors, and to ensure that our Minnesotans are driven by, or our elections are driven by our constituents. So I appreciate the motivation and the values in this bill. Members, it's unconstitutional. I'd ask you to vote no.
Further discussion to the A26 amendment. I recognize the author of the amendment, the member from Goodhue, Representative Altendorf.
Thank you, Mr. Speaker. Members, I encourage you to vote yes, and let's stop the outside money coming in from out of state.
All those in favor of the 826 amendment, please say aye. Those opposed, please say no. The motion does not prevail, and the 826 amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Niska moves to amend House File Number 3, the fifth engrossment as amended. The amendment is coded A25.
I recognize the author of the amendment, the member from Anoka, Representative Niska, to explain the A25 amendment.
Thank you, Mr. Speaker. And Representative Greenman, I have a number of concerns with the foreign influenced corporation provision, and we've discussed this in the Judiciary Committee. And so I have a few amendments here to address this. It sounds really good. When I first saw the heading, I kind of skipped past it actually at first until I knew it was coming before a committee that I was going to be before, and then I dug into the details. And the details are really concerning, but I did want to start with trying to do something about the problem of the cutouts that we get and it happens on both sides of the aisle, of funds that are entirely just a fund created to take money from a foreign fund, from an out-of-state fund. And so the A25 amendment is an effort to do that. And perhaps it was just an oversight, or perhaps it was a concern about constitutionality. But you know, if this is constitutional, then I hope that we will vote for it. I think that there are a lot of unconstitutional problems with this legislation. If this is a constitutionally allowed provision, maybe it was just an oversight. And Representative Greenman, I hope you'll take this amendment. Thank you.
Discussion to the 825 amendment. I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair, and thank you, Representative Niska, and I appreciated the conversation in Judiciary. We had a long one. This, too, has the same problems as the provision with Representative Altendorf. By saying that contributors who reside outside of Minnesota, it incorporates U.S. citizens. The Foreign Influence Corporation prohibition has actually been very tailored, not just foreign nationals, but you have to be living outside of the United States. It's been tailored based on what the court says we can do, which is we can ensure and we can protect our democratic self-governance from foreign influence. So appreciate the conversation, but I'd ask, this also has constitutional problems. I'd ask members to vote no.
Further discussion to the 825 amendment. I recognize the author of the amendment, the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Greenman, for helping us out here. We as a body should not be voting for unconstitutional legislation. And this amendment, I agree, has a constitutional problem. And I'm not going to support it. I'm going to withdraw this amendment. We all swore an oath to uphold the Constitution. I think that means we should all vote against the underlying bill, but we should start by, I'll start by withdrawing the 825 amendment.
Representative Niska withdraws the 825 amendment. There is an amendment at the desk. The clerk will report the amendment.
Niska moves to amend House File Number 3, the fifth engrossment as amended. The amendment is coded A33.
I recognize the author of the amendment, the member from Anoka, Representative Niska, to explain the A33 amendment.
Thank you, Mr. Speaker, and Representative Greenman. I appreciate, again, I do also appreciate the long conversation we had in Judiciary. Maybe we can challenge that in terms of length here on the next couple of amendments. I agree with you absolutely wholeheartedly that we should be for self-governance. We should be for Minnesota voters deciding Minnesota elections. We should be for taking out-of-state and international voices that are too loud and making sure that Minnesotans have the right to decide Minnesota solutions for Minnesota problems. I'm concerned about the bill, the way that it's crafted, and I'm concerned in particular about the constitutionality of this legislation. But let me start first by pointing the body to federal law. 11 CFR 300.35 already prohibits foreign nationals from contributing in any election, not just federal elections, but state and local elections as well. So we already have federal law in this area. We have a federal standard, and so Representative Greenman, if she will yield, Mr. Speaker.
Representative Greenman will yield. Representative Niska.
Thank you, Mr. Speaker. Representative Greenman, you spoke very at much length when we were talking about the express advocacy about us aligning ourselves with the federal standard, and so I'm confused as to, and I'd like to hear your explanation as the author of the bill. Why are we passing any law whatsoever in this area, but if we are going to pass a law in this area, why are we doing something that conflicts with the federal standard?
I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker, and thank you, Representative Niska. This doesn't conflict with the federal standard. This closes a loophole that Citizens United opened with the federal standard. What the federal law that you just quoted does is it prevents foreign individuals from spending in our elections. And you accurately described it's state, local, it's federal. But after Citizens United, what it did is say if you're involved in a corporation and you spend money through that corporation, that federal prohibition that you said doesn't apply. So what this bill does is it's narrowly tailored to say what we don't want is corporations that are foreign influenced, that folks who couldn't directly contribute under that law can now contribute and be involved in our elections. So this is actually a loophole closer that rides and actually rides alongside the federal law that you and actually bolsters it.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Greenman. Respectfully, I have to disagree with your characterization of this as closing a loophole in Citizens United. I think it's pretty clearly designed to shut out all corporations, especially all publicly traded corporations, from participating in our election process, and only for-profit corporations, not nonprofits or labor unions, which we'll discuss on my next amendment. But I did want to talk specifically about a couple of the problems that I think that this bill or that this amendment fixes in the definition of foreign influence corporations. Because I agree that we shouldn't allow a foreign national who controls a corporation to hide behind that corporation. That's the point of this amendment.
Hey, Kevin.
But your bill, the underlying bill, is worded very differently than dealing with the situation where a foreign person dominates or controls or even has meaningful influence in a corporation. In particular, it says, it defines a foreign influence corporation as one shareholder holding 1%, or all shareholders owning 5%, or any shareholder indirectly influencing the decision-making of a company. And so, as we discussed in the Judiciary Committee, federal securities law actually interacts with the way that this works. In particular, Regulation 13D requires shareholders to disclose at certain points in time, shareholders in a publicly traded company, to disclose that they actually own shares. And a publicly traded company, unless 13D is tripped, doesn't actually know who their shareholders are on any given day. Millions of shares of some of the biggest companies trade daily. Every publicly traded company has shares that trade daily, and Regulation 13D requires a Schedule 13D to be filed only 10 days after one shareholder or a group of shareholders working together exceed 5%. So Representative Greenman I'm concerned that the CEO certification, along with that one shareholder of 1% and an aggregate shareholder of 5%, will create an impossibility for the CEO of any publicly traded company to ever make that certification. So, Mr. Speaker, if Representative Greenman will yield.
Representative Greenman will yield. Representative Niska.
Representative Greenman, in the Judiciary Committee, I asked you if there are any publicly traded companies that would ever be able to file the CEO certification, and you didn't know. I was wondering if you were able to answer that question today. Is there any way that a CEO of a publicly traded company, under the way the bill is drafted currently, the underlying language that I'm trying to fix with this amendment, is there any CEO of any publicly traded company that could file that certification? And if you could explain how that works under federal securities law.
Representative Greenman.
Thank you, Mr. Speaker, and thank you, Representative Niska. I think that question you're asking is better framed to a CEO of a multinational company. I would say that when you're talking about publicly traded companies, some of the biggest companies in the world that do amazing big things, the idea that they wouldn't be able to tell you who their investors are is concerning, deeply concerning. I think what this does is just require a basic level of corporate governance. And what we're talking about is if these foreign influence corporations can spend money in our elections. We're saying that you have to certify, if you're going to spend money in a Minnesota election, that you actually have to show that you're not a foreign influence corporation. I think that when we're talking about these companies, there's far greater compliance issues that they have under SEC law. I am not an SEC lawyer, so I will not speculate than that. But this is just knowing who your investors are is just a fundamental function of corporate governance.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Greenman. I appreciate that answer. I think that it's actually extremely enlightening. And what it means, members, and I actually have done a little securities litigation. I've done a little bit of reading on the federal securities laws. I've traded stocks. I've owned stocks on a record date, which means that I have had the ability to indirectly participate in their governance in every way, including whether they participate in political speech. What Representative Greenman's bill does, and what this amendment is trying to fix, is it disables every publicly traded company. And we're not just talking about the biggest publicly traded companies. We're talking about any company that has decided to avail itself of the public securities markets because someone who started a business and built a business wants to sell some of their business in order to cash out. Every business that has, for-profit business that has decided to be publicly traded by Representative Greenman's bill that we're trying to fix is muzzled. For-profit corporations are allowed to speak. Labor unions are allowed to speak, regardless of their foreign influence. But every corporation, publicly traded corporation under this bill, is defined by what we're told is a carefully crafted definition. I think it is carefully crafted. It's carefully crafted to try to eliminate the First Amendment rights that the U.S. Supreme Court said that groups of people, when they organize themselves as a for-profit business, have. That is exactly what happens. And the third clause in the definition is even worse. I referenced this a little earlier. It says that a foreign influence corporation is a corporation in which a foreign investor participates directly or indirectly in the corporation's decision-making process with respect to the corporation's political activities. I'm sure many of you have received a proxy statement from something in your retirement account. That means that you held that stock on the company's record date. Every company has a record date where the shareholders who happen to own it on that date get to vote on the board of directors of the company. Representative Greenman's bill makes it so that any company with a single foreign shareholder is now, on their record date, is now muzzled from participating in the First Amendment, from participating in Minnesota elections. So I really appreciate Representative Greenman, your reference to the Constitution on the two previous cases or two previous amendments. I think that we should take that very seriously here. The A33 amendment is going to really fix what I think is a fatal constitutional flaw in this bill. It requires a corporation to file the underlying bill requires a corporation to try to prove a negative by filing a certification that it is by law impossible by the facts and the legal scheme of our federal securities system and the way that securities markets work makes it impossible for any CEO of any publicly traded company to meet. The federal courts are not going to be tricked by this one weird trick to circumvent Citizens United. They will see through it. They will strike down the underlying bill. But the A33 will fix that. It will save Minnesota from some constitutional litigation. I think it will save Minnesota from having to pay attorney's fees when that constitutional litigation succeeds. And so, members, I ask that you vote for the A33 amendment. And, Mr. Speaker, I request a roll call.
Representative Niska requests a roll call vote. Seeing 15 hands, there will be a roll call vote on the A33 amendment. Is there any further discussion to the A33 amendment? I recognize the member from Anoka, Representative Stevenson.
Thank you, Mr. Speaker. Members, I ask for a no vote on the A33 amendment. The 1% threshold that's defined in this bill is significant, and it's established both in law and in fact. 1% of a publicly traded corporation is when an individual starts to have influence over the decisions of that corporation. That's been acknowledged by the Business Roundtable, one of the largest business groups in the country. It's been acknowledged by the SEC. It's been acknowledged by both Republican and Democratic members of the SEC, including appointees of former President Donald Trump, by Republican members of the U.S. Congress. That 1% threshold is a significant threshold. It makes sense. Representative Greenman is correct that this bill closes a loophole. We do not want associated citizens that are foreign influence to be contributing to our elections. So I ask for a no vote on the amendment.
Further discussion to the A33 amendment. I recognize the author of the amendment, the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Stevenson, for pulling very neatly a point made by the Center for American Progress, which drafted this legislation. The reality of this legislation, though, is that 1% is only a threshold of influence if the corporation knows, if that shareholder has gone to that corporation and spoken to them. That's not what this bill does. That's not what the underlying bill does. The underlying bill requires the corporation to know even those shareholders who might have 1%, or even those aggregate shareholders who might have 5%, who have chosen not to speak to the company. And it requires the CEO of the company who doesn't know whether there's a 1% shareholder who hasn't announced themselves to the company, or doesn't know whether just in aggregate there happen to be 100,000 foreign shareholders that add up to 5%. It requires that CEO to file a certification before they are allowed to speak. So it may be that we could have crafted a different bill that would have been somewhere in the middle, that might have met constitutional scrutiny. But this bill does not meet constitutional scrutiny because it tells a specific class of speakers that the U.S. Supreme Court has already said have First Amendment rights and makes it impossible for them to exercise their First Amendment rights. The federal courts are not going to be tricked by our one weird trick to circumvent Citizens United. They're not. They're not. This law will get challenged, and it will lose. And then our taxpayers' money is going to go to lawyers for the challengers of this bill. That's what's going to happen if we don't adopt the A33 amendment. I don't think that's a good idea. I don't think that's a good use of our tax dollars. I know we've got a big surplus, but I still think that's not a good use of our tax dollars. It's definitely not a good use of our tax dollars 2 or 3 bienniums down the road when the bill comes due and when our budgets have created a situation in which the state is already probably going to be facing some deficits instead of surpluses. But more fundamentally, it's not a good idea because we in this chamber are accountable to the voices of the people out there. We are accountable to the marketplace of ideas, and we don't get to say who gets to speak or not. That's the point of the First Amendment. That's the point of the First Amendment. That's an important principle, and that is part of the Constitution that each one of us swore to uphold our oath. So I withdrew my unconstitutional amendment. I think it's important that we all vote for this to make this underlying bill a little bit more constitutionally compliant. Please vote for the A33 amendment.
The clerk will take the roll on the A33 amendment. Will the clerk please call the name of the member who's voting remotely?
Hassan.
Hassan votes no.
Hassan votes no.
The clerk will close the roll. There being 59 ayes and 69 nays, the motion does not prevail and the A33 amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Niska moves to amend House Law Number 3, the 5th engrossment as amended. The amendment is coded A34.
I recognize the author of the amendment, the member from Anoka, Representative Niska, to explain the A34 amendment.
Thank you, Mr. Speaker. And well, I'm disappointed that we weren't able to fix that constitutional problem in this bill. But I'm optimistic, actually, that we can come together on this one. Like I said before, Representative Greenman, when I saw this, the headings on this bill, when I first saw it was introduced and I was flipping through it, I thought it sounded like a good idea, probably pretty non-objectionable, probably something I could support. I mean, like I said, I'm all for Minnesota self-government. I'm all for Minnesota solutions to Minnesota problems. But then as we dug into the details, I'm very concerned about the definition of foreign influence corporation that we just went over. I think it's clearly unconstitutional. But I got concerned about some other aspects of this bill as well. I spoke to some election lawyers and some other stakeholders, and I heard, honestly, some kind of nefarious claims about the bill. So I hope this amendment is a chance to clear the air and kind of fix some of that. In particular, I heard some claims about the authorship and the drafting history of this bill, that it's a model bill from out of state. And so in the interest of pursuing Minnesota solutions to Minnesota problems, can you help clear up the drafting, Representative Greenman, if she will yield?
Representative Greenman will yield. Representative Niska.
Thank you.
Representative Greenman.
Thank you, Mr. Speaker, and thank you, Representative Niska. This provision was actually drafted by Representative Stevenson. I will say I've been working with the Campaign Legal Center on this as well, and I know a lot of people are interested in how do we keep foreign influence out of our elections. We've seen, and it is a concern, and I think we're all talking about it today. So I know that the city of Seattle has a provision like this. Lots of states are looking at it because that they're worried too. This is not just a Minnesota problem. It is a problem of foreign influence going through a loophole in our elections. So if you have any further questions, I'm going to send it back to you, but Representative Stevenson is the original drafter of the bill.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Greenman. I think you're now the second person who's thrown Representative Stevenson under the bus when I asked a question. I appreciate the answer. I'll be honest, I'm a little skeptical about where this bill came from, and so if Representative Stevenson will yield.
Representative Stevenson will yield. Representative Niska.
Thank you, Mr. Speaker. Representative Stevenson, I'm skeptical about where this bill came from because I've read some papers from the Center of the American Progress, and I also noticed something strange in the bill language on line 26, 23 through 25. It prohibits foreign influence corporations from making a contribution to a candidate for election, nomination, election, or appointment to a public office or to a candidate's principal campaign committee, or making a contribution to a political committee, political fund, or political party unit. And as I'm sure you know, Representative Stevenson, Minnesota statute section 211B.15 already prohibits all corporations, whether foreign influence or not, already prohibits all corporations from engaging in those activities. All corporations are disabled from giving direct contributions to political candidates, as I'm sure you know, as a candidate and as an attorney as well. So if this was a Minnesota bill that you drafted, Representative Stevenson, why did you include language in this bill that's already totally covered by existing Minnesota law?
I recognize the member from Anoka, Representative Stevenson.
Well, Mr. Speaker and Representative Niska, I'm really glad you asked this question because I will admit I was a little offended when you said earlier that this was a copy and paste job. I remember this bill when I first had the idea. I was reading the newspaper one morning and I saw what the people in Seattle had done on this issue, and I thought that that was a really good idea. And so I worked with House Research to craft this bill. And as to your specific question about that provision, as an attorney, I'm sure you're very familiar with the idea of belt and suspenders. And I remember discussing this specifically with House Research and thinking that it was a good idea to be duplicative in case we change the law over there to make clear that even if we're going to allow corporations to make contributions that they are currently not allowed to be made, that we certainly don't want foreign influence corporations to be made. It's a belt and suspenders approach.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Stevenson. That's very creative. I know you're good on your feet, and I think we all saw that today. You're a skilled trial attorney, but the facts are the facts, and the facts are that the Center for American Progress, which is a nonprofit corporation, has put this language in a model piece of legislation that they have put forward. That's where the city of Seattle got it from. And so this bill is the Center for American Progress's model bill. A nonprofit corporation, which for some reason is allowed to speak under the language of the bill, but for-profit corporations are not. But it gets better. It gets better, members. The Center for American Progress actually discloses on their website who their directors are and who their donors are, some of their donors, certain large donors, and they actually aggregate how much of their donations come from foreign governments. Not foreign individuals, not foreign organizations, foreign governments. The Center for American Progress, the organization pushing this model legislation, takes money from foreign governments. In some recent years, more than 1% of their total donations were from foreign governments. I'm pretty sure they also take donations from foreign individuals and foreign organizations, but they are funded by foreign governments. This legislation is literally, by its own terms, foreign-influenced legislation, members. That's why we're trying to fix it. It's like the snake eating its own tail. It is foreign-influenced legislation. What's also interesting about this bill is that while it chooses to disable for-profit corporations with foreign involvement, it chooses not to regulate certain other entities. So international labor unions, for example, do participate in our Minnesota election system. SEIULIUNA, IBEW. Every single one of those organizations has the word international in its name. Why do you think that is? Why do you think that is? It's because they have foreign involvement in their labor union. So, Representative Stevenson, I guess you're the one. You're the one to ask about this, Mr. Speaker. If Representative Stevenson will yield.
Representative Stevenson will yield. Representative Niska.
Thank you, Mr. Speaker. Representative Stevenson, labor unions aren't covered by this legislation. Was that just an oversight, or was that a deliberate choice in drafting this legislation?
Representative Stevenson.
Well, thank you, Mr. Speaker, and thank you, Representative Niska. In this particular issue, when I was drafting this legislation, as I mentioned, or as Representative Greenman very clearly articulated, we were trying to close a loophole with regard to foreign contributions from foreign nationals that we believe that the Citizens United decision and other related decisions opened up. I'm interested in the idea of looking at not-for-profit corporations that are foreign influenced and labor unions and the other group. So it's an interesting discussion to look about, but it wasn't the problem I was trying to solve with this bill when I authored this bill.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Stevenson. You know, it sounds like maybe you guys are going to take my amendment. There's a big problem, I think, if we're singling out certain speakers and not other speakers on the same grounds. And I think this problem is also very evident when we're talking about nonprofit corporations. There's a particular Swiss billionaire who's been recently in the news. I think we all have an article about him at our desks. There's been an investigation into this particular individual's not a United States national, but he's been very, very involved in the American election system. His influence is broadly felt through millions of dollars routed through a network of nonprofits that invest heavily in the democratic ecosystem. His sister, in a biography about him, said that what was important to him was finding out how he could exert influence through his foundation. This individual just happens, coincidentally, just happens to also be on the board of the Center for American Progress, the nonprofit that's pushing this legislation. So, Mr. Speaker, if Representative Stevenson will yield again.
Representative Stevenson will yield. Representative Niska.
Thank you, Mr. Speaker. And same question as it regards labor unions, Representative Stevenson. Why were nonprofit corporations excluded? And they were very specifically excluded from this bill. Why were they excluded? Was that just an oversight as well?
Representative Stevenson.
Mr. Speaker, Representative Niska, it was not an oversight, neither was the last one, as I said. We were trying to solve a specific problem with this bill. I'm interested in the problems you are mentioning, and I think that there could be follow-up legislation that builds upon this legislation. I'd be interested in working on that.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Stevenson, for confirming that it was not an oversight. It was a deliberate drafting choice, and I've got great news for you. I have the follow-up legislation. It's the amendment that we're considering here. A34, as a lifelong Minnesota Twins fan, I love the fact that I got A34. I hope we have a lot of other Kirby Puckett fans in this chamber. And so, Representative Stevenson, I look forward to your yes vote on the board. I'm going to ask Mr. Speaker for a roll call.
Representative Niska requests a roll call vote. Seeing 15 hands, there will be a roll call vote on the A34 amendment. Anything further, Representative Niska?
Thank you, Mr. Speaker. And this is a really common sense way to make sure that we are treating all like speakers alike. When the federal courts see this piece of legislation the way it's written, they're not going to like the fact that we targeted certain kinds of foreign influenced entities and not other kinds of foreign influenced entities. And frankly, I don't think the people of Minnesota are going to be very happy when they see that a trifecta treated certain kinds of entities different than other kinds of entities, and they're going to draw some inferences about why that is. So members, let's try to minimize the damage that we're doing. Again, this bill is unconstitutional even with this amendment, honestly. But let's try to minimize the damage that we're doing out there in the free marketplace of ideas. If we're going to try to rope in foreign influence, we have to treat similar organizations similarly, and we definitely should not pass the underlying bill the way it's written, which is foreign influence legislation. Please vote for the A34 amendment.
Discussion to the A34 amendment. I recognize the member from Anoka, Representative Stevenson.
Well, Representative Niska, I am also a Twins fan and a Kirby Puckett fan, but unlike Kirby in the 91 series, you struck out. This is a bad amendment that should be voted down, and it's not ready. It's a good idea to look at the not-for-profit issue and the other issues related to it, but I think it's ironic that you just had an amendment where you argued very strenuously that the threshold should be 50%, changing it from 1%. Now in this amendment, you're at 5%. I see no consistency there. When you talk about treating things similarly, there's no consistency in your approach to this at all. I already mentioned that the reason why we selected 1% in the bill itself was grounded in a well-established principle about when individuals have influence in an organization, because again, we're trying to curb foreign influenced corporations, and so there is a background for why 1% is chosen. There is no such background for this amendment for 5%, and that could be the right number, it could not be the right number. And what should happen is a bill should be introduced and we should have a hearing and a discussion, and we should move that way. But today, I'd ask for a no vote.
Discussion to the A34 amendment. I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker, and thank you, Representative Niska. This is a really critical amendment. This amendment, so in her introductory remarks, Representative Greenman said that this bill, the underlying bill, will eliminate foreign influence from corporations. And she is right. This will have an impact on foreign influence from corporations. However, this underlying bill will have no impact on foreign influence from nonprofit organizations or from unions. None. So thank you, Representative Niska, for having the foresight to see that it's really important to eliminate foreign influence from those groups as well. So let's talk about the foreign influence behind this bill, behind the very bill in front of us, and why this amendment is so important. And I'm going to give you a little history here, a little background. Perhaps it's more detail than you want, but it's clearly detail that you need. So there's this really broad network of nonprofit organizations. They funnel money, they fund political activities. That's what they do. You often hear this in the vernacular. You'll hear this called dark money, right? These are dark money nonprofits. They are not transparent about where their money comes from or what the money is used for. Frankly, thankfully, we've got some investigative journalists and reporters in this country who have dug through a lot of documents. So these reporters, IRS agents actually, experts, have waded through all of these nonprofit filings and reports to give us just a little glimmer of what's going on. So I'm going to try my best to connect some dots for you. So some of these dark money nonprofits are groups like the Open Society Foundations, the New Venture Fund, Democracy Alliance, Center for American Progress.
And there are foreigners directly influencing these dark money nonprofits. There are foreigners who are directly donating to these dark money nonprofits. And Representative Niska referenced one, but I'm going to talk about one particular foreigner and how he is influencing U.S. elections, Minnesota elections, through these dark money nonprofits, through this network of nonprofits. So there's this Swiss billionaire. His name is Hans Weiss. I actually asked our resident German speaker for the correct pronunciation, and I still got it wrong. Hans Weiss. That's his name. And you should have an article at your desk on Hans Weiss. I passed that one out. So he's this Swiss billionaire, and he has funneled hundreds of millions of dollars, perhaps as much as billions. We're talking real money, folks. This is not couch cushion money. Oh, it sounds like, well, perhaps 1.6 billion, but perhaps billions of dollars to these various democratic and progressive groups that influence our elections. That's their whole purpose. Interestingly, there was, in fact, is it in this article? Do you know? There is an article, the sister of this Hans Weiss, she actually said, this is her referencing her brother, what was important for him was to find out that he could exert an influence through his foundation. That was his purpose, to exert influence through his foundation. That's what she said regarding his brother. So that's what Hans Weiss, that was his goal, that was his purpose. Now, this part is kind of crazy. Between 1990 and 2006, so this is not ancient history, right? However, we are past the statute of limitations, so it's not prosecutable. However, during that time, this Hans Weiss donated $119,000 directly to candidates and political committees. Directly to candidates. Now, clearly somebody got wise to that because he doesn't do that anymore. He can't donate directly. For some reason, the FEC declined to take action against him, but it didn't happen. So he no longer gives money directly to candidates because he is a foreign national. However, since that time, to two of these nonprofits I've talked about, 1630 Fund and the New Venture Fund, just two of them, and frankly, they share the same address as the founder and the management firm, they have collectively received $245 million donated by Weiss, since 2016. This is just a few years, $245 million that Hans Weiss is using to influence our elections. Our elections. And I'm going to say directly in the state of Minnesota, and I'll get to that. I'll connect that dot in a few minutes. But here we have a foreign national who gave over $100,000 directly to candidates illegally, and then switched over to funneling money into politics through these dark money nonprofits. So just in case you're wondering how this relates to this bill, particularly, and to the state of Minnesota, the New Venture Fund, which is one of these nonprofits directly funded by Weiss, they're one of the founders of Isaiah here in Minnesota. And Isaiah is one of the groups who has openly and vocally lobbied in favor of this legislation. They are funded by New Venture Fund and Hans Weiss. Foreign influence in this bill before us today. So here's some other fun facts about Hans Weiss. So currently he serves on the board of the Center for American Progress. By the way, that organization also funded the study and wrote the model legislation on which this foreign influence
I guess I shouldn't assume. Representative Stevenson said he wrote this language with the help of nonpartisan staff. I believe that the model language, however, has been distributed. Does everybody have that? So everyone should have the model legislation from, and this is directly from the website of the Center for American Progress. So this is directly from their website. I just printed it off a few minutes ago, and I went through and compared this model language to the model language in our underlying bill, and lines 25.24 through 25.27 are in addition. Those lines are not in the model language, but the rest of this foreign influence corporation language is virtually identical to the model language found on the website of the Center for American Progress. I think that's remarkable. That is a remarkable coincidence. Perhaps it's miraculous. Maybe even some might call that bonkers. Some might call that bonkers. That language is virtually identical to the language in this bill. So this billionaire, the Swiss billionaire, Hans Wies, he sits on the board for the Center for American, the Center for American Progress. This organization, by the way, has taken money directly from foreign governments. They have taken money directly from Japan, Taiwan, the UAE. Talk about foreign influence. The governments themselves have donated directly to the Center for American Progress. So members, if we really care about getting foreign influence out of politics, and we should care about getting foreign influence out of politics. This has become a huge issue in the news, probably since the 2016 election, right? The talk mostly then was about Russia, but frankly, Russia's clearly not our problem. This is a Swiss billionaire. Like I said, the governments of Japan, Taiwan, the UAE have given to this group. So if we really care about getting foreign influence out of politics, then certainly we are going to prohibit Swiss billionaires and the nonprofits that they run from being able to influence our elections. This is easy. Like I said, I mentioned Isaiah. We've all heard about Isaiah. We know that they're an affiliate of a group founded by Saul Alinsky. But are we aware that Isaiah, who has been publicly lobbying on behalf of this bill, were we aware that they have received money directly from Hans Wies's New Venture Fund and the Open Society Foundation? Directly. We're not just talking about foreign influence in elections. We are talking about foreign influence in the bill before us. Foreign interference in this bill. This bill, this provision in this bill, this is not about ending dark money or about curtailing foreign influence. That's not what this is about. If it was, then these dark money nonprofits, these unions like SEIU, IBEW, LIUNA, International is literally in their names, they would be included. We wouldn't want their foreign influence either. But frankly, they are specifically excluded from this underlying bill. We specifically, in the underlying language, we specifically exclude all the foreign influenced dark money that flows through foundations and nonprofits. Folks, I hope I have connected some dots for you. This is not hypothetical. This is not, well, maybe this could happen. You can't get a more direct connection than what we've got here. And again, I would implore you, please take the time. Read a little bit about Swiss billionaire Hans Wies. We're making it really easy for you. We put the articles right on your desk for you. Take the time to compare the language. Again, you can go to the website for the Center for American Progress. That's where I got this. I printed this off, I don't know, half an hour ago now. Compare this language from Hans Wies's organization. Compare this language to the language in our bill. And I assume that everyone in this chamber will vote yes on the Niska amendment to ensure that we are getting all foreign influence out of our elections, not just some.
Further discussion to the A34 amendment. I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. Is this amendment divisible?
Representative Quam. Representative Quam, I have reviewed the amendment and I have conferred and consulted the chief clerk, and it does not appear to us to be divisible, but if you have a proposed division, you can certainly present that forward at this time.
Mr. Speaker, line 1.2, dividing that out from the rest so that the issue that was brought up, oh, the 5%, we don't like the 5%, we like the, there is understanding. This would say, basically it'd be adding or labor union.
After reviewing the amendment is not divisible. Discussion to the A34 amendment.
Mr.
Representative Quam.
Thank you. Can you explain why just adding in or labor union? See, I listened intently to the questions that were being answered by a member over here. And it was consistently his issue, oh, but you've got the 5%, you got the 5%. There's good points you're making. We didn't originally include, well, this, by just adding or labor union means international labor unions with international influence in them would be treated the same as any other international influence. I thought that was the intent of this bill that we were trying to do, is avoid international influence, but apparently the issue is that we don't mind if it's some influence, we're just after one type of influence. And that bothers me. And I attempted here to save this so that we could have it better by just putting in or labor union. But apparently, that was too much to swallow. And I guess the writing's on the wall. Only some international influence is bad. That's what is being said here.
Further discussion to the A34 amendment. I recognize the author of the amendment, the member from Anoka, Representative Niska.
Thank you, Mr. Speaker and members. This is a no-brainer. This is a friendly amendment. This is trying to take this bill from something that the federal courts are going to look at. They're going to say, you silenced these kind of foreign speakers, foreign influence speakers, and you chose, and they're going to see that we chose to carve out nonprofit corporations. It's very clear in the bill. It defines corporation by referring to Clause 1 and Clause 3 of a definition of corporation. Clause 2 is nonprofit corporations. It's going to be very clear to the federal courts. They're not going to be tricked by the fact that we are choosing, if we don't adopt this amendment, to allow foreign influence nonprofits to participate in our elections. And they're going to see that we're choosing, by voting down this amendment, to allow foreign influence labor unions to participate in our elections, that we're picking and choosing which speakers get to participate in the free marketplace of ideas that the First Amendment says that we as the state of Minnesota don't get to control. It's going to be very obvious to the federal courts. I hope it's obvious to everyone here. I hope it's obvious to everyone here. And like I said earlier, we all swore an oath to uphold the Constitution. That's why I withdrew my amendment. And when Representative Greenman correctly pointed out that it's unconstitutional. I'll be honest, the A34 amendment doesn't fix the constitutional problems in this legislation, but it does make it a little bit more defensible. It at least gives the Attorney General's office a puncher's chance. Representative Stevenson, I was a little offended by your reference to me striking out in reference to the immaculate number for this amendment, the A34 amendment, in honor of Kirby Puckett, because I'm actually here missing my son's first varsity baseball game, trying to help us to fix this unconstitutional piece of legislation. He did score a run. I'm told, I learned on Game Changer as we were sitting here. But absolutely, the A34 amendment, frankly, the underlying bill struck out. And the A34 amendment is, let's at least take a swing, hope to foul off a pitch. The 5% threshold, Representative Stevenson, that you said that this has no basis, it absolutely has a basis. It has a basis in the 5% threshold that we're applying to the aggregate ownership of a foreign corporation. The 1% threshold isn't the only threshold in the underlying bill. The 1% threshold is about an individual person, and that's about their ability to submit a statement, a ballot proposal. So I agree that the 1% threshold doesn't make sense in the nonprofit corporation, but when we're talking about 5% aggregate in the for-profit corporate context, absolutely, the 5% threshold in aggregate, in the labor union context, and in the nonprofit context, there's a basis for that. It's called equal protection. It's called treating like alike. It's called making sure that we are signaling to the federal courts that are going to evaluate this and signaling to ourselves that we are at least trying to be compliant with the federal Constitution. But members, I think it should be painfully obvious by now that not only is this bill unconstitutional, the underlying bill, if it's not fixed, but it is self-defeating on its own terms. It is literally foreign influence legislation. And I actually appreciate Representative Stevenson for coming over and showing me some emails that proved to me that it was unintentionally foreign influenced. Representative Stevenson had this idea in 2020. It looks like from the email he showed me that it wasn't from the Center for American Progress, but the Center for American Progress article that laid out all this model legislation was from 2019. If you want, to go to the Google machine, it's an article called "Ending Foreign Influence Corporate Spending in U.S. Elections" on the Center for American Progress website, dated November 21st, 2019. So we've got a choice before us, members. Are we going to ban certain speakers under the guise of ending foreign influence, and in the process enact foreign influence legislation? Or are we going to try to treat similar speakers similarly, try to do a Minnesota solution to a Minnesota problem, and adopt the A34 amendment? Members, it's Game 6 of the 1991 World Series. Kirby Puckett's at the bat. I hope you vote for A34 amendment. Thank you.
Okay. The clerk will take the roll on the A34 amendment. Would the clerk please call the name of the member who's voting remotely?
Hassan.
Hassan votes no.
Hassan votes no.
The clerk will close the roll. There being 58 ayes and 66 nays, the motion does not prevail and the A34 amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Davis moves to amend House File Number 3, the fifth engrossment, as amended. The amendment is coded A28.
I recognize the author of the amendment, the member from Crow Wing, Representative Davis, to explain the A28 amendment.
Thank you, Mr. Speaker. Members, the A28 amendment is really a common sense safety amendment meant to further secure our elections, to secure the integrity of our elections. It simply says that voters who register on Election Day will cast their votes on a provisional ballot. That way, their vote still counts 100%. But we have time to verify that the person is who they say they are and that they live where they say they live. We already do this practice with pre-registration. I actually spoke with a county election specialist just the other day on this subject within my district, that a county election specialist is someone that the county actually hires to run their elections. And we had a great discussion about how if someone did want to do some kind of tomfoolery in our elections, the time to do it would be registering the vote on the day, or registering the vote on the day that you do vote. Because she said it takes us time to actually verify that a person is actually eligible to vote in this state. It takes them time. That's why pre-registration gives them, I believe, 21 days to do it. But when you register on the day that you vote, that does not happen. You go in, someone can vouch for you, like if you don't have a driver's license, someone can vouch for you. And you could be deceptive about it. And the person vouching for you could be deceptive about it. And you could vote, your vote gets banked. And then later, if we find out that you are not who you say you are, and you do not live where you say you live, that vote does not get deleted from the process. It's already banked. And so this amendment, the A28 amendment, is just, again, a real common sense amendment that says, hey, your vote is going to count, but we're going to actually make sure you are who you say you are and you live where you say you live. Members, please vote yes for this amendment. Thank you.
Discussion to the A28 amendment. I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair. This is a long amendment, but for folks who haven't read it, this is the provisional balloting bill that's been introduced. And what provisional balloting does is functionally eliminate same-day registration, which Minnesota's had since 1974. Minnesotans like same-day registration. It's worked for us. This provisional balloting bill is both expensive, but more importantly, it eliminates something that has made Minnesota the highest voter turnout district many states, many years. So please vote no.
Discussion to the 828 amendment. I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker, and I need to correct the statement that was just made. This does not eliminate same-day registration. In fact, if you look at and read it, it says that if you same-day register on election day, you do a provisional ballot. You might not understand, but less than 2% of the people that live in the United States live somewhere that doesn't have provisional ballots. HAVA, Help America Vote Act, federal regulation, the vast majority of states and people have the option of a provisional ballot. The provisional ballot makes sure that you are not disenfranchised because you go in, and even if there's some problem, you get a ballot. It guarantees it. And boy, the hard thing that would be to do provisional ballots, my goodness, turn around to almost every state. And they have provisional ballots because they actually abide by HAVA. They actually follow federal election law. What a concept. We should be following federal election law, but we're not. And frankly, this amendment would take care of it so we actually follow federal election law, that we aren't an abnormal outlier that doesn't have provisional ballots guaranteeing that you do not get disenfranchised from being able to vote. Now, I don't understand why. Maybe it's because some people think that we aren't capable of doing provisional ballots. I think that we're just as capable as California, Washington, Oregon, Wisconsin, Iowa. You know, just keep on naming them. But we aren't doing it. We want election integrity. We want election, we don't want to disenfranchise anybody, but we don't want to follow federal law. Everybody else, almost everybody, I stand corrected, there's only like 97, 98% of the people live where they have provisional ballots. They're not ever, you're not denied being able to go in and get a provisional ballot. So I'm just shocked that anyone would have, well, I guess, lack the confidence in the capability of the state of Minnesota to do what just about every other state does. There are a couple states smaller than us that are also exempted from it. So if I don't have my paperwork, I get there really late, and I'm going to register. I can register same day. I can get a ballot. And that ballot is just as good as any other ballot, but it needs to be verified. Because I don't know if you looked at the Legislative Audit Commission on our registration, tens of thousands of bad registrations. So after the fact, if you happen to have tens of thousands of bad registrations, after the fact, when they're commingled, you can't take them out. Well, I don't know if this is, what's the constitutionality in that? Well, in 2008, the United States Supreme Court, Crawford versus Marion County Election Board, in the majority opinion written by Justice Stevens, and Justice Stevens decided a lot of split decisions because he was the deciding vote. He wasn't overly conservative, wasn't overly liberal. On page 10, he talks about election fraud, public confidence. Public confidence. Page 12 of the majority opinion. Risk of voter fraud real and could affect close elections. Well, you know, a few hundred votes deciding a statewide might be considered a close election. Page 13 talks about safeguards that are needed. And page 14, the availability of the right to cast a provisional ballot provides an adequate remedy. So the majority of the U.S. Supreme Court in 2008, so it was before a lot of the controversial stuff we've been hearing lately. You know, frankly, since we're the outlier, the U.S. Supreme Court sees this as being an adequate remedy and helping ensure public confidence so that people aren't worrying and questioning. I think this is a great amendment. During the sample audit after the regular audit of the voter registration system, they discovered that tens of thousands of bad registrations that were flagged weren't cleaned off of the voter rolls, that they ended up voting. So I think we might have some stuff to improve our confidence. There are tens of thousands of registrations that HAVA requires, if you don't have these forms or this information, that you have to go to a Social Security Administration website to verify. Well, he's finding that website right now. But on that, and that is publicly viewable, the results of that. I went and looked at that, and you know, Minnesota, on the parts I looked at, were 18, 20% of all of the ones we go through on that failed. Bad registrations. During the legislative audit of our registration system, when it was discovered that that was present, there were, I think the 2016, there were over 16,000 bad registrations in that election cycle, over 15,000 in 2018. And they also found out that Minnesota tends to be a tad bit slow in running things through verification. So if you look at the rest of this amendment, it says basically that you're actually going to check this in a timely fashion. If you cared about integrity and you cared about following what just about everybody else seems to be able to follow, you'll vote for this amendment. And anyone that wants to, I can get you the links to those audits. I can get you the link to that Social Security Administration site. I can send you the letters that I received from the auditor, from the Secretary of State, from county, the head of elections at several counties, like 15 counties. So you can have a better view exactly of what reality is. So if we're going to actually do an election bill, this should be a first step, because at least then we'd be federally compliant with our election law. So I hope you can vote green. Thank you.
I recognize the member from Hennepin, Representative Nelson.
Thank you, Mr. Speaker. And members, deja vu all over again. We heard this the last Two bienniums, the same argument. We are HAVA compliant with our elections. We are given an exception in to the HAVA rules for provisional balancing, along with 2 other states, because we have same-day registration that allows our people to vote. The other states that have provisional balloting are ones that do not allow their people to vote on the same day they register. We do. That's why we are HAVA compliant. And this argument that's been put forward, it's been put forward the last 4 years, at least, and even longer than that, but because we are HAVA compliant, because we are exempted, because we allow the people to vote on election day when they register. And so members, vote no on this amendment.
Further discussion to the A28 amendment. I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker. And first, I will just address what was just said. So when you have a waiver, it doesn't mean you're compliant. It means you're non-compliant with a waiver. You've been given a waiver, so you are allowed to be non-compliant. However, the vast majority of states who allow same-day registration pair that with provisional balloting, which is really logical. Because when you register the same day, there is no verification of your eligibility to vote that day. None. And in the state of Minnesota right now, you cast that ballot, it is immediately commingled with all of the verified eligible voters' ballots. They're all commingled. There's no way to tell the difference because, of course, once that ballot is in the machine, there's no taking it back. So, and I appreciate Representative Quam mentioned the Social Security Administration data. I had actually already pulled up that website. And in fact, I'm pretty confident Representative Quam is the one who introduced me to this website a long time ago. And so I just want to show you some examples. This is from the week of, I just pulled up some random weeks. The week of October 1st, 2022, so about a month before our election. That week in Minnesota, there were a little over 5,000 voter registrations. 472 of those did not match. 472 voters who registered that week could not be verified as eligible voters. 472. Just that week. Just that week. I pulled up a lot of different weeks. Obviously, we were getting close to the election at that point, so there were a lot of registrations. We don't typically have that many in a single week. But as we get closer, here is the week of October 8th. There were 7,500, 7,600 registrations that week. 781 of them could not be verified. So we're up over 1,000 votes right now out of just over 10,000 votes, almost 10% voter registrations could not be verified. This is a legitimate, real-life problem. And, you know, I mean, I think Representative Quam referenced also, you know, some of the best data we have is from 2008 because we had a recount. Yes, we had a recount that year that resulted in a very close election. It was a matter of just a few hundred votes in a statewide race. What we found at the end of that is that there were literally thousands of same-day registrants who were never verified, who could not be verified. And what we do, the process for that is after somebody registers to vote on election day, a postcard is then sent to that voter. So these folks who could not be verified, either the postcard came back as unverified, it was maybe a bad address. There were literally postcards sent to addresses that did not exist. Empty lots. They did not exist. And yet, those ballots were commingled with all of our verified registered voters' ballots. This is the epitome of disenfranchising legal votes. When you water down a legal vote with an unverifiable voter,
You disenfranchise those legal, eligible voters. For the life of me, I cannot figure out why this is a problem. Because we believe that these ballots should still be counted. These ballots absolutely should still be counted after they are verified. This is not difficult. And frankly, you know immediately, this is easy to figure out. You've got the ballots cast on Election Day. You know how many that is. You have the same-day registrations. You know how many that is. This is not magic. This is just math. You know how many same-day registration ballots there are. You've got those sequestered in a separate, secure box. Then what you do is you verify those same-day registrations, and once those are verified, then you count those ballots and add them to the totals. Now, more often than not, let's be honest, more often than not, it's probably not going to change the result of an election. But that's fine because we've got time. Elections are not certified the day of the election. So why are we so worried about having that ballot in the count on Election Day? Because guess what? That's not the official count. The count we get on Election Day is not the certifiable official count. It's not. And that's current law. So it only makes sense to set those ballots aside, verify the registration status, and then 100%, absolutely, do not certify that election until those ballots, those eligible voters, their votes are counted. Because there would be nothing worse than disenfranchising another voter. That is a sacred, sacred privilege we have in this country. And it should not be messed around with. It should not be watered down by allowing folks to vote illegally, whether intentional or not. We're not saying that this is even about fraud, because it's probably not. It might be perfectly reasonable, accidental mistakes in filling it out. But guess what? We still need accuracy. We still need to know that every vote being cast is by an eligible voter. This is a no-brainer. Vote yes on this amendment.
I recognize the author of the amendment, the member from Crow Wing, Representative Davis.
Thank you, Mr. Speaker. And Mr. Speaker, before I forget, I'm going to ask for a roll call vote.
Representative Davis requests a roll call vote. Seeing 15 hands, there will be a roll call vote. Representative Davis.
Thank you, Mr. Speaker. Thank you, members. This bill does nothing to address the fact that someone can fraudulently register to vote on voting day, cast their vote, and then have their vote commingled with everybody else's vote. This bill does nothing to address that. And I heard earlier from a representative in this House, on this House floor, about deceptive practices, keeping deceptive practices out of our elections. That's exactly what this amendment is all about. Protecting Minnesota's elections from deceptive practices without hurting someone's vote. Members, if you vote yes to this amendment, it gets included in this bill, and if this bill passes, which I know you have the votes to pass this bill, then at least right here, we have the ability to add some security, more security, which is a good thing, to our elections. I got to tell you, we the people are the ones with whom all inherent power of government has been given. And it is given to us by Almighty God. And we have a duty on this House floor to protect what God has given us. The blood of patriots wasn't spilled for us to idly stand by and not do whatever we can to protect the security and integrity of our elections. This amendment does just that. And I would ask that you would prove to Minnesota tonight that that is exactly what you want to do. You want to continue to secure and to protect the integrity of our elections. Members, we can all vote green on this amendment tonight, and that is what I'd ask you to do. Thank you, Mr. Speaker. Thank you, members.
The clerk will take the roll on the A28 amendment. Will the clerk please call the name of the member who is voting remotely?
Hassan.
Hassan votes no.
Hassan votes no.
The clerk will close the roll. There being 57 ayes and 68 nays, the motion does not prevail, and the A28 amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading as amended.
Third reading, House File Number 3, as amended.
Third reading as amended. Discussion to House File 3. I recognize the member from Hennepin, Representative Kraft.
Thank you, Mr. Chair. Representative Greenman, thank you. This is such a great bill in so many ways, especially because of the values it celebrates. That our democracy works best when more people of every generation, race, gender, background, and political persuasion participate. So I could talk about the whole bill, but I'm going to focus on one part of it that is especially near and dear to my heart, and that is voter pre-registration for 16 and 17-year-olds, and I'm proud to talk about this. This is great policy because it encourages young people to build a relationship with the political process as early as possible, helping them make voting a lifelong habit and setting them up to be lifelong participants in our democracy. And that with young people, it's their future that we're often debating. So we're all better when they participate more in it. So why is this such a good policy for Minnesota? So first, voter turnout. So most students turn 18 during their senior year, which is typically a time of transition in their lives. Intuitively, it should be easier to establish a new habit, voting, if youth are thinking of themselves as voters before this time of transition. The data actually proves this. Studies have shown that with 16, 17-year-old voter pre-registration, there is an increase in subsequent voter turnout in the 18 to 29 age bracket, and that increase ranges from 2 to 9%. And in Minnesota, while we do a great job on voter turnout, young people is an area where we can improve. If you look at the 2018 and 2020 election, the gap between the youth voting age group of 18 to 34 and those older ranges from 10 to 34%, depending on the election. So we can do better here. Now, the great news is that this is easy for us to do because we already do it. Today, we allow 17-year-olds to pre-register if they're going to be 18 by the time of the next general election. Now, lastly, Many other states already do this. A total of 15 states plus Washington, D.C. already allow 16 and 17-year-olds to pre-register. And these are both Republican and Democratic-leaning states, including places like Florida, Louisiana, North Carolina, and Utah. So I hope we can all agree that it is a good thing when more young people participate in our democracy, regardless of their political persuasion. Voter pre-registration for 16 and 17-year-olds is a fantastic and incredibly cost-effective way to make that happen because, again, it's simple for us to do, it works in increasing voter turnout, and it's being done in both Republican and Democratic-leaning states around the country. So, I urge your support of House File 3, and as part of voting green, know that you'll be sending a clear message that we want and encourage young people to be lifelong participants in our democracy. Thank you.
I recognize the member from Hennepin, Representative Robbins.
Thank you, Mr. Speaker. And I've really appreciated the debate tonight. I've learned a lot. I appreciate everyone's hard work. And I'm opposing the bill. I'm so disappointed that some of the amendments that our side brought up on provisional balloting and some of the other issues were not adopted because I think it would have really strengthened this bill. I'm just going to raise a concern about sort of the practical side of how this voter registration is going to occur on the automatic voter registration side. So back in 2018, the Office of the Legislative Auditor produced a report talking about all the problems that are in our current statewide voter registration system. And then in 2019, they issued another report updating what had been fixed, and honestly, it was not very much. And so I just want to quickly identify for you the current problems in our statewide voter registration system and argue that the addition of the automatic voter registration system is going to create even more problems. And we haven't even addressed what the OLA identified back in 2019. So they currently said the problems are duplicate and inaccurate application processing. Overtaxed voter registration system already. They cannot keep up with what they currently are processing. The counties are not complying and have poorly articulated post-election sampling requirements. Incomplete identification of potentially ineligible voters. And this one, I'll just read a little bit more. It says the statewide voter registration report identifies potentially ineligible voters, but it does not identify a particular subset of voters who were inactive. And many county election officials do not use the report to identify the ineligible voters in their jurisdictions. Members, the current system already has a lot of problems that have not been fixed since 2018 and 2019. And this bill, by adding the automatic voter registration component, not only does that voter registration, but it also is complicated because we have to distinguish between who is registered to vote and who is given a driver's license but may not be eligible to vote. And on top of that, they're getting additional data from the Department of Public Safety and from the Department of Public Health. All of those systems are going to merge into an already taxed statewide voter registration system. Members, automatic voter registration system may be a good idea at some point, but it is not prudent to do this when the current system is not functioning well. And we are opening ourselves up to a host of problems about ineligible voters voting or not being able to be verified. And I urge members to vote no on this bill until the current system is up to date. Thank you.
I recognize the member from Hennepin, Representative Igbaje.
Thank you, Mr. Speaker. I just want to first and foremost say thank you to Representative Greenman for bringing this forward. This has been definitely a labor of love, and as you know, fighters for democracy, I think that this is an important bill and a great step in that direction. So I want to talk kind of about a couple of different things about this bill that I really appreciate, particularly on the voter participation side. So voter participation and increasing engagement in our elections is crucial to ensuring that more Minnesotans, whether they've been here for generations or more recently became new voters, that they have an opportunity to have a say in their community. This access to the ballot box gives them a sense of belonging. They do not need to rely on others to make choices for them about choosing their representatives. And new voters say that they get a sense of liberation and empowerment when performing their civic duty. By enhancing access to voting, whether through ease of registration, language access, or protecting voters from voter intimidation, this bill makes it clear that we want Minnesota to be a state where people vote. And Minnesota does pride itself on being a state with a high voter turnout, but we also have significant pockets where voter turnout is significantly lower and people's ability to vote is depressed. For example, in some areas of my district, the voter turnout rate is often in the 40 to 55% of registered voters. And that doesn't even consider the remainder of the eligible voting population that has yet to register. That voting population is depressed because of the locations of the polling stations, the lack of information or even misinformation about voting. And there are organizations who work every election cycle knocking on doors just to simply educate people about the upcoming election. And their work is nonpartisan because they understand the power of the vote, and they want to make sure that communities who have had a history of being held back from voting know when and how to exercise their right to vote. In a number of our districts, another thing that prevents people from voting is lack of access in the language most familiar to them. Making a decision as important as voting should be in a language that you are fully comfortable in. And I'm glad that we're forward thinking about this to ensure that the top 3 spoken languages after English in Minnesota will be printed for voting instructions and sample ballots. This bill also allows for translation and interpretive services to support those who may need assistance in voting. And this is especially important for new citizens and new voters who may still feel comfortable in their home language. And it is important that every person has equal access to the ballot. This bill makes it possible for more people to register we're advancing automatic voter registration and pre-registration for young people, as we've heard, and it provides more transparency about the voting process and protects more people when they go to vote. Overall, expanding democracy and access to the ballot is a good thing, and I'm glad to vote yes on this bill and encourage members to do the same. Thank you, Mr. Speaker.
I recognize the member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. And expanding access, then we should have had the provisional ballot, because that's how you guarantee that you get a ballot. It's been touched on, but looking at the information when the auditor looked at the registration system, and they looked back and they used a week, end of August, first few days of September, as a sample to see when the verification of those registrations were. On January 22nd was a date they verified what the quantity were checked. From the beginning of September all the way through almost the end of January, over 40% had not been verified. They didn't know. Was it a good registration? Was it a bad registration? 40% is not trivial. If we are expanding automatic voter registration, it'd be nice if we actually made sure the system was working. DPS is part of the group that was helping with the verification. And, frankly, they're part of the group that wasn't able to do in, September, October, November, December, January, almost a half a year. They weren't able to verify the registrations, and they had over 40% they never verified by that time. So, frankly, apparently, it's not a priority for our current system. NGOs. My first example or introduction to NGOs being involved in politics was a nonpartisan NGO running a forum and debate. I got there a little early and I noticed somebody else pulled in just before me, and a lady got out of a station wagon. And as I walked by the station wagon, I saw a bunch of my opponent's signs. I went to the room that I was supposed to go to, and that the person running the debate I was doing was the lady that got out of the vehicle with my opponent's signs, and that was an impartial NGO. But we don't, care about that. In fact, with the current bill, we don't care if it's foreign influenced NGOs, foreign influenced entities in our elections. And I care about what the people feel. And if you don't feel confident about our integrity, and I don't think there's a person here that doesn't realize a pretty substantial group of our citizens are concerned about that. But, apparently if you're watching from home, you see how the conversation goes. I bring up points. I had plenty of data. I've got copies, and I invited anyone that had issues or needed clarification, come find me. But it was already decided, it seems to be, what could be included in this bill and not. But the only audience is not just the people on this floor. The audience is the public and the citizens of the state of Minnesota watching us, either live or watching it later. And frankly, I beseech both the people here and the people watching to look this stuff up. See if what we're talking about is correct or not. But I'm going to sit down now because it doesn't matter if I spew a lot of facts and truth, because it seems like this might be preordained. Thank you.
I recognize the member from Hennepin, Representative Coulter.
Thank you, Mr. Speaker. As I've spent time on the House floor, I found myself reflecting, frankly more than I expected, on that Latin phrase at the front, vox populorum est vox Dei. It's an interesting phrase and a slightly different take on the more commonly heard vox populi, vox Dei, the voice of the people is the voice of God. And thanks to my Bloomington Public Schools education and my 9th grade Latin teacher, Mr. Becaris, it immediately stuck out to me, partly because grammar-wise it's a little bit wonky. But the more I thought about it, the more the difference in those words made me think about what it really means. You see, populi is the singular possessive form of the word people. Populorum, though, is the plural possessive form, meaning of the peoples. So the phrase in the front of the House chamber is actually the voice of the peoples is the voice of God. All of the different peoples who make up our state with our different needs and values and abilities, these voices collectively are the voice of God. And as somebody who taught Sunday school for 13 years, I spent a lot of time talking about why it's pretty important to listen to that voice. House File 3 furthers that ideal. It centers the people, or the peoples, of Minnesota in our elections. It ensures that the ballot box is accessible to everyone and that elections are reflective of who we really are as we really are, that they are expressions of that vox populorum. It ensures that someone's ability to vote is not dependent on a certain time of day or what language they speak. It makes clear that the choice we make when we vote is ours and ours alone. It doesn't belong to someone who wants to intimidate, harass, or deceive others into submission, and it sure doesn't belong to a foreign corporation. And it further ensures that when someone tries to affect that decision, We know who they are and where their money came from. This is a really good and important bill, and I am excited that we're going to be passing it today. But at the same time, I wish that much of this bill weren't necessary. We shouldn't have to protect voters from intimidation, harassment, or deception. We shouldn't have to spend so much time on who is spending how much money trying to influence voters. But the events of the past few years have forced our hand, particularly the Citizens United ruling and a very real rise of certain elements who seem to believe that abusive and harmful ends justify the means, even at the expense of our democracy itself. Now, I'm a process nerd, obviously, because I just translated Latin for all of you. So for a long time, I felt really frustrated because it always felt like pulling teeth to get people to care about the processes involved with voting and elections and campaigns, because generally speaking, it just wasn't something that really seemed to matter to folks. But that's changed in the last few years. As I've talked to folks in my district and others, they care about these really important process pieces. People are finally drawing the connections between how elections happen and how actors in the political sphere affect the choices voters make and how the decisions before people like us that affect their lives are made. I know that I can always depend on Minnesotans to defend and strengthen our democracy, which is precisely what this bill does. And we are doing so in a way that puts the voices of Minnesotans, with all our complicated and disparate beliefs and needs and ways of deciding and doing things, front and center, much the way that Latin phrase is in our House chamber. Minnesotans want it to be easy to register and to vote. Minnesotans want voters to be protected from interference and intimidation. Minnesotans want to know where the money funding the ads they see is coming from. Minnesotans want elections that reflect us. Representative Greenman is right. This should be about Minnesota voters. They should be valued and centered in this discussion. House File 3 makes it clear that we are doing exactly that. I am proud and grateful to be a co-author and voting yes. And I ask that you all join me in doing so. Thank you.
I recognize the member from Anoka, Representative Engen.
Well, thank you, Mr. Speaker. Let's talk about democracy for the people. Let's talk about House File 3 here for a little bit. We've heard a lot of phraseology that, quite frankly, it's on the face of it, perfect. If it truly was just about protecting democracy, expanding voting rights, or ensuring access to the ballot, I think you'd have a lot of green on that board tonight. I think that we could say that Minnesota should continue to be a leader in expanding and ensuring access to voting rights, which we already enjoy that privilege already. But that's not the only thing that this is about. You know, it also was made clear by Representative New Brindley that this is a bill written, pushed for, and funded by a foreign billionaire who has direct ties to nonprofit organizations who've been influencing elections. Hans-Georg Weiss. Well, let's talk about some of the other groups that he indirectly funds. Arabella Advisors, a nonprofit organization that also owns a network of affiliate groups, and they spent $1.5 billion on Democrat advocacy in 2022. They took in $1.6 billion in anonymous donations per their 2021 tax filings. They're not a foreign-owned corporation. As this bill states, there's no foreign-owned corporations that can influence our elections. No, that's a nonprofit, and we have a carve-out for that. Let's talk about the North Fund. This is from an Axios article. It's also not a foreign-owned corporation. They have at least 50 trade names to date. They share an address with each of those trade names. They all share the exact same address, but all tied back to the North Fund. And the names that they choose for those organizations, they all are given a sound of a grassroots political organization or campaign efforts, such as Floridians for a Fair Shake or Fix Our Senate or the Voter Engagement Fund. But that's all funded via a Swiss billionaire. It also funded Courier Newsroom, which launched as an objective news organization, according to Bloomberg. And a few months after the 2020 election, FEC complaints were filed by multiple groups, and Facebook had to pull their digital ads after it was found that they were masquerading their seemingly objective news organization as a political entity. They released curated digital newspapers to swing voters in swing states under newspaper names that folks would believe were from their local hometown, such as the Virginia Dogwood Press or the Arizona Copper Courier. That's also what this bill does. It doesn't just expand access. It doesn't just protect democracy, as we love to hear those platitudes, but it does a lot more than that. And that's why we have reservations. I think originally, if you're reading that bill, you're going to assume that whoever wrote it was doing it based off of good intentions, that they want to clean up politics. But bills like this one are the exact reason why Minnesotans don't trust politicians as much as gas station sushi. It's bills like this one that claim to be cleaning up corruption that are in and of themselves corrupt. Foreign money will be dictating Minnesota elections from this bill for the people. I'm not going to vote for this. Instead, I think that we should put together an actual bill that actually cleans up politics, that actually takes foreign influence money out of our elections, and ensures that Minnesotans are determining our elections and not Swiss billionaires. Thank you. Vote no.
I recognize the member from Goodhue, Representative Altendorf.
Thank you, Mr. Speaker. So I rise today. I have been on the election committee. And coming into the committee, all Minnesotans that we want to have elections be transparent. We want these to be fair. We want to build confidence in our election systems. These are universal. Of course, everybody wants to know when they go place their vote that their vote counts. This has been a disappointing process. We, as sitting on the election committee, the Democrats have not honored or listened to amendments. They have not had us listen to our bills. I was told that elections typically have always been a nonpartisan group. And for good reason why. We want to make sure our elections are fair for everyone. For good reasons why, Minnesota. This is one sacred place, one sacred committee that we all should agree that we have fair elections. Now, in a time in Minnesota and in the United States, are we questioning the integrity of our elections? We as a body should be working day and night to be building the confidence, to making sure the transparency is there, to making sure that every Minnesotan feels that their vote is important, that their vote counts. And yet, with this bill, we get the exact opposite. We are not making our election process seem that it's tightening up. That's not happening here today, Minnesota. When November 8th happened, and the Democrats were happy, they have the trifecta, right? That's what we hear. They have the governor, they have the Senate, they have the House. Seems like the election process worked for you in 2022. So one might think, why then are we doing things with our elections to loosen them up, to make people question? Why then, if you have the trifecta, are we not reassuring the minority party? Why are we not reassuring everyone that our elections are fair, that they are transparent? Instead, we're doing the exact opposite today, Minnesota. We're doing the exact opposite. We have shown today that with the money that's coming in, so the amendment that I offered was to say that we would not take outside money. We hear a lot of words, and one of the words they like to throw around is dark money. That dark money is coming into these elections. Well, because of our finance campaign laws, you can see where the money is coming from, and you can see where $30 million for the Democrats came from out of state. $30 million. And yet they are the ones saying dark money as if it's coming from the other side. This is a fact. Tom Hauser, KSTP, November 7th, said that this is a record-setting year of money piling into Minnesota. This was said, and it was said, but it came in on the Democrat side, not the Republican side. This is public record. We just heard tonight of foreign influence affecting the law and the legislation that's literally coming in on this election bill, and yet this is falling on deaf ears. Foreign influence is helping to write these election laws, falling on deaf ears. Yes, Democrats, you have the trifecta. Yes, Minnesota, right now, Democrats are ruling the governor, the Senate, and the House. But you know what? Integrity happens when you do what is right when no one is looking. Integrity happens when you are doing what is right. If the door is not locked, it does not give you permission to go into the house and to steal. When the speed limit is posted at 55 miles per hour, even though your vehicle can go 100 miles per hour, that does not give you permission to break the law. And right now, even though the Democrats have the trifecta, they have full control of this House, of this body, elections should be sacred. Elections should be bipartisan, and this is not. Today, Minnesota, the Democrats are taking their trifecta and they are ramming new election laws down our throats, and I am asking everyone to vote no against this bill.
I recognize the member from Wright, Representative Hudson.
Thank you, Mr. Speaker, members. Representative Coulter, I think we both suffer from some seat positioning bias. You find yourself staring at Vox Populi, Vox Dei. I find myself glancing over to the clock on the other side of the chamber, and the words written under that, reason is the life of law. And one way to apply reason, to apply logic, is to look for patterns, look for consistency. And I think as objective observers look at this piece of legislation and look at what's being done here today in the state of Minnesota, they could not be faulted for recognizing a lack of consistency. Much has been said about the inadequacy of the intent to remove foreign influence from our election process with this bill, which narrowly targets very specific forms of foreign influence from corporations and ignores that from nonprofit organizations, ignores that from union groups. And I think even going beyond the scope of what we're discussing today, we've seen arguments made in this chamber that have had the effect of increasing and even confessing to a large degree of foreign influence upon the policies that we've considered here in this chamber. I go back to driver's licenses for all, where we offered an amendment to make it very clear that these driver's licenses that are being issued to people who are not eligible to vote because they are illegal immigrants, that they be marked as such, that they have a different orientation, that they be marked as not for voting purposes. And these were provisions that had previously been agreed to in prior sessions where there have been broader bipartisan support. And what we were told, this is not impugning motive, this is reciting things that were said on this floor. What we were told at the time by that bill's chief author is that we weren't going to adopt that amendment because that policy had not been approved by the, quote, community. Now, I guess we can infer what is meant by the community, but certainly it was reference to people who don't have election certificates. It was reference to people who are not in this room. And judging by who we had here advocating on behalf of that bill, it's pretty fair to assume that we were dealing with a fair degree of foreign influence. Nobody seemed to care. So it's a lack of consistency that drives a lack of trust in what this body is doing and the effect that it's going to have on elections. The status quo in November of 2002, or in November of 2022, according to Gallup, only 59% of Americans said they were either very or somewhat confident that their votes were counted properly in American elections. That's down from 75% in 2006. It was 70% as early as 2018. And when you break it down by party identification, 85% of Democrats say that they can trust the process. Only 45% of Republicans do. And that's a huge problem. It's a huge problem because when you lose public trust in public processes, especially something as sensitive as how we select the people who are going to wield political power in our state and in our country, when people lose confidence in that process, it creates dangerous situations. And this bill has been presented as a solution to dangerous situations, but it's actually inflaming the very causes of that, which is lack of trust in the process. I've had constituents contact me. I've had conversations with people where they've said on multiple occasions that they don't trust the process, and they're not sure whether or not they're going to engage with it anymore because they believe, quote, my vote won't be counted properly anyway. And that's in response to both the status quo and what's being proposed today. That is a form of disenfranchisement. That is a form of voter suppression. When you erode people's trust in the process down to 45%, that's the same thing as not letting them vote at all. I would think twice about this bill. Thank you.
I recognize the member from Hennepin, Representative Bonner.
Thank you, members. We may debate many things, but there is one point on which I'm certain we agree. Safe, secure, and fair elections are the cornerstone of our democratic process. Within this bill, I'm going to speak to one particular section, a mechanism that does just that. It's called automatic voter registration. It's a funny name because there's little that's automatic about the process. The system begins with elaborate checks and balances to verify that you as a voter are who you say you are, you live where you say you live, and you are, in fact, an eligible voter, and that you're ready to make your voice heard. And in case you're wondering, we also check to make sure that you might not be an eligible voter in this process, to make sure that things are fair and transparent. These checks and balances are robust, like multi-factor authentication on steroids, I like to say. But by far the best reason this provision stands out is that voters who understand what AVR does overwhelmingly support it. And I want to give a quick quote here. The former Secretary of State of Kentucky, a Republican, said voter registration issues can be fixed with a few common sense reforms that conservatives and liberals alike should support. Along with a commitment from election administrators to do what is necessary to build confidence in the system at a time when our institutions are under attack. Fortunately, we can vastly reduce the number of provisional ballots by overhauling our registration system, using modern technologies to ensure the name and address information is up to date and as accurate as possible. We do that through automatic voter registration. And I have many others I could cite here from Republicans, Democrats, folks in over 23 states who've already implemented automatic voter registration. But I think the real proof in the pudding, and the reason that I am here today, is that I think the bill as a whole, automatic voter registration, and all of the components within this bill, really what this bill does, and I just want to recenter us because we've heard lots of talk tonight. But what this bill does is it recenters the people at the heart of our democratic process. This bill is about the people. It is a bill for the people. It is about what people are asking us about. Over the summer, my team knocked roughly almost 15,000 doors. Most of those 15,000 I knocked myself, me personally. I talked to thousands of voters. I talked to thousands of folks at the state fair. I talk to folks in my community all the time. And I can tell you when I've talked to folks about things like automatic voter registration, when they get it, they're all in. When I talk to them about things like making sure that we have transparent, fair, and secure elections, talking about knowing who's trying to influence your vote, there's no debate. This bill didn't come from some billionaire somewhere. This bill came from voters, people that I have talked to personally, thousands of them, thousands and thousands and thousands of them. And I can tell you that the people at the doors, my voters, my people in Maple Grove, people across the state at the state fair, conservative voters, independent voters, libertarians, they all get it. They all are asking for transparency. They are asking to know who's influencing their vote. They're asking about voter intimidation. They're asking about centering our voters and making sure that as many eligible voters have the opportunity to participate. We claim to be a beacon for democracy in this country. Minnesota has the highest voter participation in the entire country. And we do that because we focus on the democratic principles and the core values of the people of Minnesota. This bill does all of that. And for that reason, members, I ask you all to vote green.
I recognize the member from Stearns, Representative O'Driscoll.
Thank you, Mr. Speaker. Members, thanks for the debate this afternoon. I wonder if the bill author would yield to a few questions.
She will yield, Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Greenman, I am looking at the bill, and I am on page 22, lines 22.23 through 22.25. And I'll give you a moment to go ahead and find that, and just go ahead and read it, and I'll have some follow-up questions for you on that. Members and Representative Greenman, can you explain what might be no person, it talks about interference with the registration and voting process. No person may intentionally hinder, interfere with, prevent another from voting, registering, and so forth. Could you cite some examples for legislative intent on this?
I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Chair, and thank you, Representative O'Driscoll. In the 2020 election, we saw in Virginia and California, people blocking access to polling places. In Arizona, we just saw people blocking access to voting booth or to drop boxes. So there's actually ample evidence of the need to all this simply does, this provision says that no person can intentionally hinder, interfere with, or prevent another person from voting, registering to vote, or aiding another in casting a ballot to vote. Thank you.
Representative O'Driscoll.
Thank you, Mr. Speaker. And Representative Greenman, would you yield to another question, please?
Representative Greenman will yield to another question.
Representative
O'Driscoll.
Thank you, Mr. Speaker. Representative Greenman, thank you for that clarification. I want to just ask if the situations I'm going to cite to you would or would not fall within the scope of the provisions that we were just talking about. There was a group of concerned citizens that formed an organization, and they wanted to go out and raise the level of awareness of individuals in a community or in a particular election or an election cycle about if you see fraud that's occurring, here's who you would talk to, and maybe go door to door or send out literature to individuals. Would that be considered using the language in your bill? No person may intentionally hinder, interfere, or prevent another person from voting, registering, or aiding another person to vote by raising the level of awareness of the potential for fraud, and if you see it, ask and advising individuals of what to do with that.
Representative Greenman.
Thank you, Mr. Speaker and Representative O'Driscoll. I feel like I'm back in law school with the hypotheticals. I think that the facts, what the key piece in this is both intentionally hindering, interfering, or preventing another person from voting, registering to vote. So if that providing information, that's one thing. If you are preventing, interfering somebody from registering to vote or aiding another to pass the ballot, then that would be prohibited. This is both a civil and a criminal enforcement provision, and so obviously those would have bars in court.
Representative O'Driscoll.
Thank you, Mr. Speaker. And Representative Greenman, thank you for underscoring that this would have criminal and civil penalties to it. And that's why, again, for legislative intent, because I do believe this bill will probably come under legal scrutiny. And as you said, you feel like you're back in law school. There will be a review of everything that we've talked about. Lots of money and high-powered attorneys that will be arguing this in front of many courts along the way. And so I'm just trying to aid them in what your intentions are on this bill. Mr. Speaker, I'm going to ask Representative Greenman would yield to a final question.
Representative Greenman will yield to a question. Representative O'Driscoll.
Thank you, Mr. Speaker. Representative Greenman, again, for legislative intent and to help aid the courts and others who may have to interpret what the intention of this legislature was by the votes on here. If an individual walks into a polling place and says, I don't think that that individual is eligible to vote, and the judge goes, I don't know, maybe they are. Is that considered, again, in this subdivision, no person may intentionally hinder, interfere, or prevent another person from voting? Nowhere in here is a talk about good faith, and so I want to make sure that individuals who suspect others of illegally voting would be protected and not be treated as criminals and subject to civil penalties for their honest interpretation of what they believe the case to be. Mr. Speaker.
I recognize Representative Greenman.
Thank you, Mr. Speaker. I believe in the hypo you said if someone walks into a polling place, there is a procedure for challenging the eligibility, and it doesn't start with, so I think that the conduct you mentioned already may not be prohibited. And so under our current law, I don't think you could, and I would have to check with the Secretary of State, but I believe that would currently be prohibited.
Representative O'Driscoll.
Well, thank you, Mr. Speaker and members. What we've heard is we don't have a clear definition on this. So what we're going to be doing is we're going to be creating criminals out of individuals who say, hey, you know what? I know the law. I see what's going on. I want to report this. And by some chance they are wrong, they'll be charged with a crime and subject to civil penalties. You know, earlier today we had the chance to adopt the provisional ballot clause, provision that Representative Quam is talking about, which would have solved this. We could have said that person can vote, and we'll deal with it afterwards, and then we'll introduce their ballot into the box. Now a decision has to be made by people as to whether or not this individual is or is not, and if it's found out to be that they are not, it is commingled with ballots which change the outcome of elections. In this chamber and in this legislature, races were won by less than hundreds of votes. And if you don't think that it matters, it matters. Members, vote no.
I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and members. I'll try to keep it brief. I know, coming from a lawyer, legislator, that might be hard but I know I've jabbered a lot tonight. But members, it's baseball season. The Twins are in first place. They're actually thumping the Yankees at Yankee Stadium tonight. They batted through the order in the first inning. But here we are on the floor of the Minnesota House, and sadly, I think we're striking out. We're striking out on meeting the name of this legislation, I've heard it called the Democracy for the People Act. I think it's more accurately called Democrats Rule the People Act, because we've got provisions where we're reaching out into the marketplace of ideas, and we're allowing for some elected officials maybe to interfere with elections. I appreciate Representative O'Driscoll doing a little bit to drill into a provision that we haven't looked at enough, the election intimidation provision, but the enforcement provisions on that are very concerning. And I think that they are going to be subject to a constitutional challenge for the same reason that another similar law was challenged in an 8th Circuit case called 281 Care versus Arneson. In that case, the 8th Circuit said that for all practical purposes, the real potential damage is done at the time the complaint is filed, when the accused has to lawyer up to defend their speech. I think that this is vulnerable to constitutional challenge. I think that we're reaching out into express advocacy, defining express advocacy in a way that's going to chill potential speech. And I won't belabor the point. I think I've talked enough on this provision, but what's called the Foreign Influence Corporations Act is about picking and choosing groups of people in the private sector out in the marketplace of ideas who are going to get to speak. And if you don't believe me, just look at the packet that was handed out by the author of the bill. A bunch of nonprofit organizations and labor unions, including one of the labor unions that has international in its name, that all support this bill. An organization called the End Citizens United Action Fund, supporting the so-called Foreign Influence Corporations provision of the bill. I don't think the federal courts are going to be deceived by the End Citizens United Action Fund promoted legislation that's going to be the one weird trick that solves Citizens United. It's not going to work. It's not going to work. But Representative Coulter, you said something about the words up there, Vox Populi, Vox Dei. That was kind of interesting to me. You said, and I only took, I think, 2 semesters of Latin in college, so I don't know if this is right or not, but you said that it actually refers to the voice of the peoples, that people gather in groups. And it's too good to check. I think that's interesting, actually, as we're thinking about how the people of Minnesota, how the people of America participate in our marketplace of ideas. Because often, very often, I mean, I can, as an individual, I can, blog or yell at the street corner. But as people, in order to participate in the marketplace of ideas, usually we get together in groups. Usually we get together in groups, and then those groups speak with a common voice. Sometimes those groups are for-profit corporations, and they're engaging in things for profit. Sometimes those groups are labor unions, and they're, advocating on behalf of the workers in that union. Sometimes those groups are nonprofit corporations. Sometimes they're political funds. But what this bill does, as unamended, you rejected all of our amendments, what this bill does is it says, this group of people can't talk. These similarly situated groups of people, go for it. Go for it. The people of Minnesota aren't going to be fooled by what we're doing here today. The majority is picking and choosing who gets to speak in the marketplace of ideas and who doesn't get to speak in the marketplace of ideas. And we're telling people before they speak as part of a group that you need to do a multi-factor balancing test to figure out whether some bureaucrat, the members of the campaign finance board, or a majority of them, a few years down the road are going to decide that you met this multi-factor balancing test and you were doing express advocacy and you should have registered. So we're striking out. We had the A33 amendment, the Justin Morneau amendment, the A34 amendment, the Kirby Puckett amendment. Both of those would have gone a long way towards making this bill more constitutional. Unfortunately, we couldn't do that. So what we have before us today is a violation of our oath to uphold the Constitution. It is a trampling on the marketplace of ideas in order to benefit one political party over the other political party. Please vote no.
I recognize the member from Hennepin, Representative Frazier.
Thank you, Mr. Speaker. And first, I just want to say I have to appreciate Representative Niska's shout out to Kirby Puckett. Kirby Puckett grew up in the same neighborhood. I grew up in the same neighborhood that Kirby Puckett did. My mother and he attended the same high school. My dog is named Puckett because that was our compromise as baseball fans. Me from the south side of Chicago, her a major Twins fan, and she's happy right now that they are smashing the Yankees in Yankee Stadium. But I rise simply because of this. I try to draw a through line here. And when the men got together to debate and draft the Constitution for the United States of America, and they picked and decided who would be able to participate in that democracy, people that looked like me weren't included in that conversation. We didn't get an opportunity to participate in that democracy. Then the decades after, there was a fight to ensure that democracy would be open to everyone. And I cannot stand in this chamber and not recognize the privilege that I have, for one, to stand here all these years later, knowing that at the start of this, folks that looked like me did not have the opportunity to stand in these chambers and speak to the masses. And I have a privilege to represent thousands of people in my district. And this bill, thank you, Representative Greenman, for bringing it, is in large part here because we've listened to thousands of Minnesotans telling us what they want in this state, telling us that they want to have easy access to our democracy, telling us that they want to have that access protected, that they want to have their democracy protected, that they want to have their voice protected. I come from a lineage that knows true intimidation and voter suppression and what that feels like and what it was, and to fight back against that and to persist and still be here in order to provide a voice for this democracy. That is what this bill does. That is why I'm happy to press green for this bill. And I'm urging everyone in here to think about that history, to think about how far we've come, to think about how much work we still have to do to become a more perfect union, and to vote green on this bill tonight. Thank you.
I recognize the member from Chisago, Representative New Brindley.
Thank you, Mr. Speaker. I've been so focused on the foreign influence behind this bill that I haven't addressed other parts of the bill. And I'll just very quickly, we talked about pre-registration. We talked about the fact that the Attorney General and the Governor actually agree with us that juveniles should be held accountable. But in this chamber, we are not going to vote to hold them accountable here. We had an opportunity to do that today. But I'm even more concerned about a group of people who have chosen not to register to vote, who are automatically going to be registered to vote now. Now the option is to opt out, not opt in. And to be very clear, at the DMV, when you interact with Human Services, right now today, you have the option to opt in to register to vote. You get to do that right now. But we're changing that, so now the onus is on the individual to opt out. And there are situations where this can be very dangerous. Because again, All of this data, as soon as you are registered to vote, if you're 18, that data becomes public information. And now the Secretary of State is required to send you a notification that you have been registered to vote, and you have 20 days. You have 20 days, according to the language in this bill, to rescind that. You don't get to pick. When you're at the DMV, you don't get to say, wait, don't do that. They will send you a letter in which you can now take your time out to respond to this communication and say, I want to opt out. I don't want you to register me to vote. Less than 3 weeks is what you get. You get less than 3 weeks. And frankly, the language isn't entirely clear on when that 3 weeks start. Does it start on the day you receive the communication? Does it start on the day that the letter is sent out? I don't know. But you got 3 weeks and the onus is on you. So if you don't want your data to be public, too bad. Not your choice anymore. You have 20 days. You talk about the permanent absentee ballot list. Anyone can request to be on this list. And then what happens when you have somebody who moves 50 days before an election, and then 46 days before the election, 4 days later, their ballot is sent out. That ballot goes out. You've got ballots floating out there that don't belong to an eligible voter at that point. We can go over express advocacy. Frankly, it's going to be litigated. It's going to be thrown out. We don't really have to worry about it. I'm going to go back to this foreign influence of corporations one more time. I did the same thing Representative Niska did, and when this little packet of supporter letters came around, I quickly thumbed through it. Union, Minnesota Council of Nonprofits, certainly they support it. Nonprofit. It's not at all surprising that our unions and nonprofits support this bill. I passed around one more article on the gentleman we talked about, well, probably shouldn't call him a gentleman, on Hans Wies. I sent out one more article to everyone so you could read a little bit more about this foreign influencer in our elections. And not just in our elections, in this very bill. This bill right here before you today that we will be voting on was written in part by Hans Wies and his organization. So interestingly, this Hans Wies, he founded this company called Synthis Inc. Now this bill will not allow Synthis Inc. to play any part in our elections. I actually think that's a good thing. They are a foreign company. They should not play a role in our elections. However, the founder of Synthis, frankly, the person who made all of the money from the corporation, were happy to allow his foreign money in our elections. Because he's going to funnel that through a bunch of dark money nonprofits that nobody can track anyway. Nobody gets to know where that money is. So we're going to let Hans Wies interfere directly in our elections, but heaven forbid his corporation do it. Interestingly, this Hans Wies, Synthis Inc., you'll see that they've gotten into some trouble. They carried out illegal experiments on human beings. And in fact, the federal judge who heard the case said the company's pattern of deception is unparalleled. Now again, corporations don't exist independent of people. That means Hans Wies, the CEO, the founder of Synthis Inc., he is responsible for this unparalleled deception. Well, I'll tell you what, I think that unparalleled deception that Hans Wies is responsible for is showing up right here today. This is unparalleled deception. And I apologize because one of our members today told us exactly where he got it, and I appreciate that. He showed us the receipts of asking for language to be drafted based on the Washington language. Made absolute sense. Well, guess where that Washington language came from? Hans Wies and the Center for American Progress. And that language, again, is verbatim. Verbatim from their model language. There was some discussion about the 1% number and where that came from. I'll tell you where it came from. Hans Wies and the model language. It's right here in black and white. We know exactly where the number came from. But heaven forbid we would exclude corporations. We'll just let the people behind the corporations, regardless of their level of foreign influence, we'll let them influence through dark money that's not going to be traced, that people aren't going to find out about, unless, of course, we've got some really good reporters and IRS experts who are willing to dig in and find the truth. I just saw that too. We heard just a minute ago that democracy would be open to everyone. Well, today we're going to go backwards on that a little bit. Democracy is going to be open to some people. It's going to be open to our international unions. It's going to be open to our foreign-funded, foreign-influenced nonprofit organizations. It's not going to be open to everyone. This is about the worst elections bill I can imagine. And frankly, you look at this and you understand why it has been the policy of this body for years, decades, I might say, to only bring forward bipartisan election bills. That has been the policy here for years. And this bill is exactly why you can see that was the policy. Because when you allow just one party to write an elections bill, this is the garbage you get. Vote no.
I recognize the member from Hennepin, the Majority Leader, Representative Long.
Thank you, Mr. Speaker. I move a recess to the call of the chair to allow for an iftar break for Ramadan until approximately 8:45.
Representative Long moves a recess to the call of the Speaker. All those in favor, please say aye.
Aye.
Those opposed, please say no. The motion prevails and the House stands in recess.